That case was transferred to Devanahalli. The petitioners have appeared and contested the same. The petitioners, with their intention to cheat the respondent number 1 and to defeat his interest in the self-acquired property, obtained decree against him. And so it is just and proper to stay the proceedings of the petition till disposal of the suit. It is the contention of the respondents, that is the decree holders, that the decree holders are not the parties to the said suit, and the petitioners are not aware of the said suit. They have filed the suit in the year 2005, and the said suit came to be decreed in the year 2010. The respondent number 1, though knew the proceedings, did not challenge the decree. Subsequently, the petitioners has filed the petition for allotment of the share. Now they have appeared before the court. They have not filed any objections and come up with the present application. The court, by order, impugned and dismissed the application. While dismissing the application, the court has observed that on perusal of the material available on record, it reveals that the present petition was filed with the petition for drawing of final decree in terms of the preliminary decree, but the respondent number 1 filed present application to stay the proceedings till disposal of the suit in OS number 1912 of 2006, pending before the Devanahalli court. As the present petition is filed only to draw the final decree and to allot the same to the parties, there is no provision in CPC to stay the further proceedings in the final decree proceedings. If at all the suit is pending with the same party, it is for the parties to approach competent court of law and obtain the necessary orders and accordingly dismiss the petition. Land counsel appearing for the petitioner submits that the two scheduled properties are one and the same, and if this final decree proceedings are allowed, it would cause a lot of hardship to the petitioner respondent in the final decree proceedings. This aspect was not appreciated by the court. Next paragraph. Having heard the counsel for the petitioner, there is a material on record. A judgment and decree in the year 2011, which this petitioner is aware, has not questioned the same. Now, basing on a suit of 2006, which is pending before the court, the petitioner wants a final decree proceedings to be stayed. What the respondent, what steps he has taken regarding a decree, a final decree of the year 2000, a judgment and decree of the year 2011 is not forthcoming in the pleadings, and the final decree proceedings which are pending to allow this share to the parties cannot be stayed by the court, and the court has rightly passed an order, and this court finds no reasons to interfere. Dismissed.
Number 5, again the PS
Petition in this case.
Yes.
In this case, my lord, the application filed by the petitioner for filing the return statement beyond the period of 120 days.
After that, how many days?
After restoration of the suit, my lord, 97 days delay is there, my lord. First instance, they have filed the
On
suit in
120, 97.
97 days.
After 120, 97.
Yes, my lord.
Then comes for the petitioner submits that. As there was a delay of 97 days in filing the written statement, court has failed to take the same on record. He has relied upon judgment passed by a coordinate bench of this court. Ask them, there is an order, they'll give that order. So in the light of the same, they shall be stay of all further proceedings, notice and summons. In all these matters today, memo shall be filed by 18th of September. Yes, next.
Still number 6. Still number 6.
Let's appear for the petitioner. That suit is filed for the leave of specific performance of contract. That's first respondent is the plaintiff.
Where is impugned order?
Let's impugned order page 40.
Page?
It's 44. Annexure B. That's the trial court has dismissed the miscellaneous petition on the ground that notes the petitioner has to prefer an appeal. Miscellaneous petition is not maintainable. That is the reason notes the trial court has dismissed. Page 47 notes the reasons. Page 11 notes para 11.
Yes.
Quoted the judgments of the Honorable Apex Court. Let's then last para, page 50. Let's next page. Therefore, when the Apex Court has clearly added that against an ex parte judgment, the defendant can also file an appeal by challenging the decree on the ground of fraud, misrepresentation, etc., by wasting the time of the court and his own time. Petitioner or defendant is agitating this matter before this court, and this petition is not maintainable only after the outcome of the appeal. that would be filed by him in challenging the judgment and decree in vice number 45/2007 dated 14/5/2020. With the above observations, the view of the relief of filing an appeal is still available for the petitioner dependent number so and so. Miscellaneous petitioners, no summons has been served to this defendant, I mean, the petitioner is concerned. Right, summons has been served on the defendant number one. It's not, only memo has been filed, through the council. Subsequently, due to some reasons, they have not appeared before the court. Personally, this petitioner has not appeared. Immediately within, the in time, miscellaneous petition has been filed, miscellaneous has been dismissed only.
Please come. Then counsel for the petition. No, take notice, will
Please.
notice to the respondents and summons.
Bill number 7, date to the
Yes.
Constituent order dated 10/4/2026, 10/7. Page number 30, annexure C.
Is what is wrong with this order?
That to avoid multiplicity of proceeding, my lord, the first response suppressed and he has filed a false genealogical tree and he has not brought the legal aids of the.
No,
Gaurappa
which
and
is the
Kotrappa.
impugned order? Page number?
30, my lord. Page number 30. The second para,
Page number 30.
please. It is in the order sheet. After perusal of the judgment and decree of the court, Honorable Appellate Court in RA number 63, the respondent was already brought on record, original proceeding at the time. The respondent have not taken any such contention, contending that suit is bad for non-joinder of necessary parties. At this stage, the view of the judgment and decree possible in both the suit and appeal, contention raised by the respondent 1 and 2 are not sustainable.
No, how come you're taking this ground now?
Please, my lord, there are
You are a party to the proceedings.
I am the party to the
Yes,
proceeding. I am the first
judgment is-
respondent.
Yes, judgment is passed, decree is passed.
There are four female members to Kotrappa and Gaurappa.
What were you doing all the while?
They are not brought on record and they have also legal rights to over.
That's what family members, you're aware of it, that they are your family members and they should be parties to the proceedings.
The suit was filed by the first respondent. He has not.
Whatever it is, you were there, you were contesting the matter. Suit of which year?
2018.
And suddenly, at the time of drawing the final decree, you realized that.
We brought to the notice of the court saying that they are also necessary parties.
That's what, why you suddenly realized this is the question. Where is your affidavit? IA, where is that IA?
IA is annexure B.
Page
Objection.
number?
We filed objections to the final decree proceeding, saying that these are all the parties are necessary to adjudicate the
Let's
matter.
see, where is that IA?
IA is objection. Just we have filed objection annexure B.
That's what, where is it? Page number?
Page number 15. It is in Kannada language.
Simple, one, yes, please come. Agreed with the order. Passed in FDP number 6 of 2022. Dated
Dated 10/7/2026.
10/7?
26.
10/7/2026 by the senior civil judge JMSC as secretary, the petitioner, respondent before the FDP court, the respondent before the FDP court and the petition herein is before this court. When the FDP proceedings were filed, the petitioner has filed his objections stating that there are some more parties and they are not added as the parties to the suit. And as and all the necessary parties are not impleted, the suit cannot be, the final decree proceedings, the judgment is bad and the court cannot go with the final decree proceedings that came to be dismissed by the court. The court has observed that the appellate court has passed an order in RA number 63 of 2018. And by the time the petitioner herein who is the respondent number 3 in the final decree proceedings, was already brought on record. And at that time, the respondents have not taken any such contention, contending that the suit is bad for non-joint of necessary parties. At this stage, the contentions raised by the respondents are not sustainable. Further, at the earliest point of time, when the original proceedings were going on, the respondents have not taken the respondent petitioner has not taken such contentions, and in view of Order 1 Rule 13 CPC at this stage, without talking about the said contention, without taking the said about the said contention at the earliest point of time, it is not they are not they cannot take such a contention at this point of time, and accordingly dismiss the same. Then counsel for the petitioner has reiterated the contention that was stated before the trial court and submits that the court ought not to have gone with the execution proceedings, as his judgment and decree suffers from the proper and necessary parties were not made parties to the proceedings. Next para. Having with the land counsel the petitioner for the material on record. The petitioner, who is a party to the proceedings, had never taken such a plea. When the matter is posted for judgment, at this time, when in the final decree proceeding, such a contention was taken. The court has rightly considered all these aspects and rightly dismissed the petition. And this court finds no reason to consider the same, accordingly dismissed.
Number 8, on procedure of petitioner.
Petitioner in this case, my lord.
Yes, where is the order?
Annexure G, page number 34. Lord, the learned trial judge directed the defendant number 4 to deposit the lease amount before the trial court in a suit for partition and separate possession, and also sought for means profit by the plaintiff. My lord, even if the suit is decreed, she is entitled for 1/3 of the share, my lord.
That to deposit.
I am not, my lord, the fourth dependent is the, my lord, lessee. He is paying the rent to me, my lord. Myself, the petitioners are the age-old persons, my lord. They are mainly depending upon the rental income, my lord. Let the trial court modify this order, my lord. 1/3 maybe.
No,
order to be
what we
deposited.
do is, let other side come.
Please,
Till such time, we'll modify now itself.
please,
You deposit that.
1/3.
Then counsel for the petitioner submits that the court has directed to deposit the rent lease amount before the court from July 2026. Then counsel for the petitioner submits that according to the plaintiff is entitled for 1/4 share.
1/3.
1/3 share. And the court, if at all, if the petitioner is entitled, the court ought to have directed to deposit to 1/3, but not the entire amount. Considering the submission, the petition is directed to deposit 1/3 amount. Notice, hand summons. Yes, next.
Number 9,
Yes.
Petitioner Mills, was my application to take the written statement on record has been rejected.
How many days?
After the original 120 days, Mills, it is 270 days, 9 months, 3.
What were you doing?
hearing. Mills, the matter is, it's a suit for injunction, Mills. All the records are pertaining to the sale deeds of 1944-45 and the various revenue proceedings. In my IA, I have clearly stated this. The impugned order at para
Counsel
2.
to petitioner submits that there is a delay of 270 days in filing the written statement. It relies on the judgment of the coordinate bench in so and so, so and so. Notice, hand summons, they shall be stay of all further proceedings.
Grateful, Mills.
Bill number 8. Fourth dependent was directed to deposit before the trial court.
The fourth defendant shall deposit 1/3. Yes, in the earlier matter. Yes, next.
Serial number 10, my lord, I pray for 2 weeks time, my lord, in this
Yes,
case.
2 weeks. Next.
number 11,
Lord, for the petitioner in this case.
President BK.
My lord, defendant's petition, my lord.
Have you
Lord, I
served
filed-
the caveator?
I have served the caveator, my lord.
Yes.
My lord, IA is at page number 46, my lord. My lord, I sought for additional issues to be framed. My lord, suit for bare injunction.
What are the earlier issues?
My lord, the title issues were not framed, my lord. I dispute the title. My lord, I claim.
Close the doors. This also. Yes.
My lord, at page number 46, I seek that, my lord, for a framing of additional issues, claiming that, my lord, the plaintiffs suit for bare injunction. My lord, they are not the true owners. I myself am a true owner. My lord, they claim the title through a unregistered GPA. I seek, my lord, subsequently a GPA was being revoked. Hence,
let's see
Please, ma'am.
already the framed issues and the additional issues which you want the
My
court
lord,
to
page
frame.
number 46 is my additional issues, my lord.
40,
6, my lord, is my application where I sought for additional issues.
the plaintiff proves that he has lawful ownership and valid title.
Please,
So
ma'am.
you wanted a suit for injunction, an issue with regard to the title to be framed.
Please, my lord, I deny the title, my lord.
Hmm.
But why I deny the title? In my application, I have stated, my lord, page number 47, para number 5, 6.
And where are the earlier issues?
My lord, earlier issues has not been put forth, my lord, I'll put forth, my lord.
Then how will the court understand without
because-
putting forth the
because-
earlier issue? Where is the order of the court?
My lord, order starts from page number 23, my lord. My lord, relevant para would be, my lord, at page number 26, my lord. There's suit for partition pending, my lord, from 2006. I'm the plaintiff there. The subject matter property is one of the suit schedule property there. Trial court says, my lord, that until adjudication of that issue, my lord, I can't claim a declaratory suit over here, my lord. I can't question the title of the plaintiff, what the trial court says.
In the present case, the defendants have merely asserted that the suit property forms part of the joint family
My lord, there is a status
property.
quo against the same property.
And the claim in the share is still pending.
Please, my lord.
Partition suit is still pending
Yes, my lord.
consultation. No final judgment or decree has been passed
Not
by the
yet, my lord.
competent court.
Not at, my lord. It's at the stage of, my lord. My lord could see at page number 28, my lord.
Uneducated and speculative mere pending of suit does not ipso facto create a clout or so and so. In this case, if they have not produced any document, they have a better title than the plaintiff. They have also not shown that the plaintiff's title is defective or doubtful. Instead, their claim is entirely dependent on the outcome of the pending partition suit. Therefore, the mere assertion that the defendants have a right to the property without any adjudicator from so and so. Court was right.
My lord, subsequently, last para, my lord.
Yes.
If in case I win over there, my lord, court says, my lord, to take appropriate proceedings again, my lord. It will be multiplicity of proceedings, my lord. It will be multiplicity of proceedings, my lord. My lord, my partition suit at is fag end, my lord.
Then I will clarify that you can't take up subsequent proceed.
My lord, please, my lord.
Please come. The agreed with the orders passed in I number 2, invoice number 704 of 2025, dated 21/8/2020. You're questioning a 21/8/2025 order now,
Yes, my lord. My lord, I have filed this.
21/8/2025. 25, whereby the court had dismissed an application filed under order 14 rule 5 read with section 151 CPC. The petitioner is the defendant in the suit. The respondent herein has filed a suit for injunction. The defendant has denied the title of the plaintiff. Now, the defendant wants a court to frame additional issues that whether the petitioner has the title, has proved that he has title to the property. That came to be dismissed by order impugned. The court had, while dismissing the application, has observed that the defendants have merely asserted that the suit property forms part of the joint family property, and they have filed OS number 1030 of 2006 before the third additional senior civil judge, Bangalore Rural District, seeking partition. They claim a share in the suit property as part of the alleged joint family estate. It is important to note that the said partition suit is still pending consultation. No final judgment or decree has been passed by the competent court recognizing or declaring the rights of the defendants or the suit scheduled property. Their claim to title is at this stage unadjudicated and speculative. Mere pendency of the suit does not ipso facto create a cloud over another person's title. A cloud over title arises only when there is a legally tenable claim or a compelling title backed by documentary or judicial support which could potentially defeat the plaintiff's asserted ownership. Further, the court observed that the defendants have not produced any document to prima facie establish that they have a better title than the plaintiff. They have also not shown that the plaintiff title is defective or doubtful. Instead, their claim is entirely dependent on the outcome of the pending partition suit, which is yet to be decided. Therefore, The mere assertion that the defendants have a right to the suit property without any adjudicated or prima facie recognizable title is not sufficient to frame an issue regarding the plaintiff's title in the present suit for injunction. The suit in question is limited in scope. It concerns whether the plaintiffs are in lawful possession and whether the defendants are unlawfully interfering with that possession. The issue already framed by this court are adequate to decide the list and accordingly dismiss the same with cause. Agreed thereby the petition is before this court. When counsel for the petitioner submits that the court ought to have ought to have framed the additional issues in the light of the respective stance taken by the parties. And in a case where the defendant is seriously disputing the title of the plaintiff. Further, the court also observed that if he succeeds in the partition suit, then they can claim such a relief. It is submitted that it would amount to it is submitted that it would unnecessarily lead to multiplicity of proceedings, and the court ought to have framed an issue next per having other counsel for the petitioner but is a material on record. The suit is for bare injunction. According to the defendant, he is the owner of the property and he denies the title of the plaintiff. To deny the title of the plaintiff, he relies on a suit filed for partition, which is pending consideration, where the rights of the parties are not crystallized. The court was right in deciding the court was right in observing that such an issue is not required in the facts and circumstances. In the considered opinion of the court has rightly dealt with and passed an order, and no interference is called for, accordingly dismissed.
Petition.
Yes, where is impugned order?
Let's, for the caveat, my lords, seek for a short adjournment, my lords.
No, caveat is not for seeking adjournment. That's his writ petition. If he wants if you are ready, argue, or else I'll hear him and pass orders.
As if may be passed over, my lords.
Yes, pass over.
For pleasure.
My lord, sir, before my lord,
Huh?
my lord, I'd like to make two submissions, my lord, please. I am questioning the locus standi of this petitioner to challenge the impugned order. My lord, he is the virginal defendant number 2 before the trial court. Your lordship may find plaint at page 62, please.
So where is the impugned order? First,
Impugned order is at page 20.
page.
20, Annex A. My lord's impugned order is passed on impleading application, please. So far as my lord's the petitioner is concerned, he is virginal defendant number 2. What is the locus of my lord's petitioner to challenge my lord's impugned order, please?
We'll hear him.
No, actually, I've
That is
challenged,
one aspect. I'll leave it.
Yes.
in this writ petition, I've challenged the other order, IA4, which is at Annexure B.
Not IA number 2.
No, because it is, you asked me to split it, so that is going into a different writ.
Yes. Where
This is
that?
for production of documents.
4.
4.
Page number. Where is the order?
Yeah, 1 second. Annexure B is 30.
Where is your IA?
Page, my lord, sir,
The IA,
40,
Annex 30, that is 38.
37.
Page number?
38. Annex D. 38 of this one.
Hmm.
So basically in the suit, Schedule C is principle number 5. Okay, and they had filed an impleading application saying somebody has created sale deeds on that property. So then I filed this application asking for the production of those sale deeds to verify that those sale deeds actually belong to suit C. The documents they produced belong to property number 17, not 5, which is listed in the schedule. So when they filed their memo as compliance towards production of documents, I filed an objection saying, hey, this is belonging to a different property. So they're not producing the sale deeds of suit C property. And the order is equating 5 and 17. It says merely because the property numbers are different, they cannot be. I mean, you can assume that they're the same because the proposed defendant is saying that.
My lords, please. My lords, so far as R5 to R9 are concerned, my lords, they are impleading applicants who are the, my lords.
Whatever it is.
I'll make
This
clear.
court has directed you to produce these
I
documents.
produced those documents to him.
You produce some documents.
No, my lords, I didn't produce some other documents, please. My lords, R5 to R9 who are impleaded and my lords who have obtained the sale deeds by way of impersonation and fraud, they did not dispute it at all. My lords, merely, that's why my lords trial court holds that merely because my lords the property number are different. At page 31, my lords, may
No,
kindly peruse what the
Is it the very same document? You
very
are
same
disputing?
document, my lords, that is
Disputing.
my lords, he is disputing it.
Hmm.
My lords, so far as my lords sale deeds, whatever that are executed, it is very much in respect of my lords suit schedule C property, please. Suit schedule C property, my lords, belongs to one MN Srinivas Iyengar, none other than my lords the grandfather of this petitioner, please. That is not in dispute at all. That is not even disputed by R5 to R9. My lords, MN Srinivas Iyengar, my lords, died in 1973. 2014, my lords, somebody impersonates MN Srinivas Iyengar and my lords has obtained the sale deed. They are none other than R5 to R8. R5 to R8, my lords, in 4 different sale deeds. My lords obtain, acquire title to my lords suit schedule C property. Thereafter, my lords, they sell it to R9, who is defendant number 13 before trial court. My lords, R5 to R9, who have obtained the sale deeds in respect of suit schedule C property, my lords, they are not even objecting all these things. I do not know, my lords, why petitioner is objecting for it. He is original defendant number 2, and my lords, he is one of the member of the joint family, and he is beneficiary of partition. My lords, if anybody who has to object, my lords, it is none other than R5 to R9, please, who have obtained the sale deed in respect of suit schedule C property. They are not disputing it.
What is the relief sought in the
Suit for partition.
partition?
Thereafter, my lords, no, my lords, it has been transposed.
What about these documents?
I have sought for declaration by way of amendment later. That has been allowed as well.
According to you, these are the documents which you sought for a
Declaring it as
declaration that
null
they are
and
not
void.
binding on- They are not binding on.
Yes, please. That
See-
has not been objected by my lords, R5 to R9.
Understood, I understood. Yes.
Say in the application, he says that they got the encumbrance certificate of the property and thereby discovered the sale deeds. But the incumbent certificate, they have taken this for 17, not 5. They very well know that this is a different property. So now you're trying to substitute documents of a different property as property of 5. That's not a small issue. So I said they're open to contempt of court, lying to court, because you very well know that this is a different property and they're trying to pass it off at 5. They are saying suit C, but the definition of suit C is now under question, because the order is trying to equate two different properties to be the same, and that's a loss of a few crores. It can't be, just taken as
Yes,
procedure.
please come.
My lords, may I just pass on this objection filed by R5 to R9 before trial court? They are not even, my lords, saying that these are not the same deeds pertaining to Schedule C property at all. Kindly peruse, my lords, their objection, please. But they did not dispute these sale deeds.
No, Your Honor, he is free to have amended the application. This is about production of the document.
Please.
He can't be producing a different sale deed and accepting.
My lords, R5 to R9 who have purchased suit schedule property, suit schedule C property under the sale deeds, whatever that are mentioned. That is not even, my lords, being said that it is a sale deed pertaining to different property, please. If anybody who have to say, my lords, it is R5 to R9. Saying that no, these not
The R5 to?
R9.
In their
Before your
favor,
lordship.
in their favor, the sale deeds are exist.
Yes, please. In respect of suit schedule C property. They did not say anything.
Agreed with orders passed on 9 number 4 of 2025, invoice number 198 of 2018, dated dated 7/2/2026. The defendant number 2 is before this court. The respondent herein, Kavita, is the plaintiff in the suit. He has filed the suit for partition. Thereafter, he has sought amendment of the prayer, sought for a declaration that the sale deeds dated 25/6/2014, 30/10/2017, and 2/2/2018 are null and void. The petitioner, who is the defendant number 2, has filed an application for production of these documents. And the petitioner, the plaintiff, the respondent plaintiff had produced the said documents.
First respondent. First respondent plaintiff.
Herein.
First respondent.
First respondent herein, who is the plaintiff in the suit, has produced the said documents. It is the petitioner has raised objection. The petitioner party in person, defendant number 2, has raised objection that the suit schedule the property
Suit schedule C property.
according to them, the documents that are produced are pertaining to some other property bearing municipal number 17.
Is there in the order itself that it's a different property?
I'm looking at the order. Municipal number 17 and not to the suit schedule C property, which is municipal number 5. Also, the encumbrance certificate produced or related to municipal number 17 and not of the suit schedule property. Hence, the documents are not pertaining to the C schedule property, and it amounts to making false statement before the court. The court, by order impugned, had disposed of the said IA as complied with, and the court has observed that on perusal of the documents produced by the plaintiff, as rightly contended by the second defendant, the documents produced by the plaintiff along with memo dated 12/9/2025 are related to municipal number 17 and not to the C schedule, but the address of the C schedule property as well as the address given in the sale deeds are one and the same. Further, the defendant number 13, who is a purchaser of the said property, has clearly admitted that he purchased the C schedule property from the proposed defendant number 9 to 12. The name of the proposed defendants found in the said sale deed as purchasers and vendors. The name of the defendant number 13 is also found in the said documents. So the proposed defendants mentioned in I number 2 of 25 and the purchasers and vendors mentioned in the sale deeds are one and the same. Therefore, considering the nature of allegations made by the plaintiffs against the said defendants, that the said documents are being created, as the plaintiff has not got amended the plaint in respect of the said allegations, at this stage, it is premature to direct the plaintiff to produce the said document Therefore, according to the plaintiff, the documents produced along with memo dated 12/9/2025 or the documents executed by defendant number 9 to 12 in favor of defendant number 13. Accordingly, the name of the said defendants reflected in the documents. Therefore, merely because property number is different, it cannot be said that said documents are not related to C scheduled property, particularly when defendant number 13 has specifically admitted in the objection statement that he has purchased as above property from the defendant. Hence, the court had disposed of the same as complied. The party in person, defendant number 2, has reiterated the contention that stated before the court and submits that it is a clear contempt of the orders of the court, and the documents which are placed are not pertaining to said property. Having observed so, the court ought not to have disposed of the IA as complied. Next, Len counsel appearing for the respondent, plaintiff, first respondent plaintiff submits that a particular, he has sought for a declaration in respect of the documents document dated 25/6/2014, 30/10/2014 and 2/2/2018. He has produced the said documents. If there is any discrepancy in the said documents, that cannot be the ground for the petitioner to say that the respondent has not complied with the court orders. Further, the parties between whom these documents are executed do not dispute the same. In those circumstances, the court has rightly considered and rightly passed an order that the order is complied with. It is submitted that the petition that is filed before the court is without any basis and the same needs to be dismissed. Next para. Having heard the counsels on either side, peruse material on record. It is an admitted fact that the petitioner has sought for cancellation of 25/6/2014, 30/10/2017 and 2/2/18 documents. And those are executed by which defendant?
My lord, sir, by impersonation, my lord, sir, R5 to R8 have got those sale deed in their favor.
It is that by impersonation, R5 to R8 got those documents into existence. And
thereafter, my lords, R5 and R8 in turn have sold it to R9.
And they have sold it to R9. The petition has filed before the court. The objections filed by
Respondent number 9 before trial court, my lord, so is defendant number 13.
respondent number 9 before the trial, defendant number 13 before the court. They do not deny those documents. When the petitioner, when the plaintiff himself submitted before the court that those are the documents which are questioned by them as not binding, the objection as raised by the defendant cannot be considered accordingly. This court finds no reasons to interfere, accordingly dismissed. Yes,
May I make one submission also? That there be direction to a trial court, my lords, to dispose of the, my lord, suit at the earliest, my lord,
Suit
because
of which year?
2018, my lords. He is coming in the,
Yes, next.
Question number 14.
Yes,
Counsel on record is not keeping valid.
yes. List on 15th of September. Yes, 15.
Serial number 15. Serial number 15, Vasant Raj. Ashwini,
Appellants. The petitioners are the defendants before the trial court.
Evator is served.
They have been served.
Yes. Where is the order?
My lord, through mail, my lord, we have sent the copy of the order is at page 28, my lord. Page 19, sorry.
Page?
19. My lord, application for amendment of the number in the scheduled property matter has been rejected by the court below. To hear A number 6 and to hear regarding A number 6, the trial, this application.
You want to amend the preliminary decree?
Decree, my lord. What has happened, my lord? The second item, the social property, actually the suit has been filed by the respondents hearing.
When was the suit filed?
The suit was filed in the year 2006, my lord.
2006.
Uh,
When was
they-
it? 8.
6, 2006.
When was it decreed?
The decree, my lord, in appeal, my lord, as a matter of fact, the suit came to be dismissed. In appeal, my lord, at page, annexure D, page 67,
Hmm.
19th April 2014.
Hmm.
Now, my lord, item number 2 is concerned, my lord. When the respondents filed a suit, it was described as survey number 405 bar B. It should have been, my lord, 405 bar 2A.
No, basing on that, basing on the survey number, a full-fledged inquiry was conducted, trial was conducted, and the suit was decreed. This is nobody's case, that the number is not wrong.
Lakshmi Fendi, my lord, I was the defendant.
We'll
Was
see
the
that the
defendant.
respondents, notice to the respondents.
16.
And someone's, yes, 16.
I'm for the caveat resolution.
Yes.
There exists a water manufacturing and bottling unit which is admittedly owned by the petitioners who are the defendants before the trial court. The plaintiff goes to the trial court and claims that there is a memorandum of understanding dated 5/1/2026 under which these two units are put in his exclusive possession for the purpose of carrying out the manufacturing activities and bottling for a period of 2 years, subject to certain payments. This is the case which is put forth by him. He also states that in paragraph number 8 of the plaint, saying that the defendant is also utilizing this property when I am not there, night he is using this property for the purposes of carrying out the manufacturing activities, etc. So he seeks for an order of injunction saying that his exclusive possession to the property and the manufacturing activities should not be disturbed by the defendants on the basis of this memorandum of understanding dated 5/1/2026, which is an unregistered instrument. The defendant enters appearance and files the written statement stating that he has not produced any documents to show that he is either authorized, he has a license, trade license to carry out any manufacturing activities. No GST registration certificates are produced. Actually, the MOU was not acted upon. We are only carrying out this entire business. He is not in possession of the property, notwithstanding this memorandum of understanding. There was a subsequent understanding which did not culminate eventually because they did not sign the understanding. Fact remains, we are in possession of the property. He goes to the police station and gives a complaint saying that no, they are in illegal possession of the property, notwithstanding this memorandum of understanding dated 5/1/2026. This is the sum and substance of the case. When the matter goes to the trial court, it is brought to the notice of the trial court that two eventualities will arise in relation to this memorandum of understanding. If it is his case that an existing manufacturing unit is permitted to be used by him, it becomes pure and simple license. He cannot claim a relief of possession. He cannot claim a relief of injunction to protect his possession because licensee will never be in possession of the property. If he says that he is in exclusive possession of the property by treating this memorandum of understanding as a lease, then the memorandum of understanding will not be relied upon by the court, or the court cannot take cognizance of that instrument to say that he is in possession of the property, it being an unregistered instrument. Two contentions were raised. Lords, may kindly have a look at the reasonings recorded by the trial court. At page number 79, the trial court order starts. Milords, at page number 90 up to page number 89, Milords, it's only the contentions which has been extracted. This is all the reasons given. Paragraph number 13. It is contended the defendant's alleged MOU is unregistered, insufficiently stamped, document cannot be looked into. It is settled principle of law that while deciding an application for temporary injunction is not proper to go into the merits of the matter. Issue can be decided after full-fledged trial. It's another contention of the defendant that as per the terms of MOU, parties have to file cases before the courts at Bangalore. It is pertinent to note that the present suit is filed for relief of permanent injunction, not for violation of terms of MOU. Allegedly, suit scheduled properties are situated within the territorial limits of this court. That's all the finding, Milords, on prima facie case.
At para 14, court says defendants have admitted this settlement deed.
Milords, the defendants have admitted a settlement deed dated 10/3/2026. Can I just pursue your Lords? May I kindly take page
No,
number
this
89?
There are two documents.
Lord,
MOU
the
is
document which is 10/3/26 is produced by us saying that it was part of a settlement which they never agreed to. Kindly have a look at page 89. The last sentence in page 89. It is pertinent to note. Lord's defendant's weakness definitely will not give them an order of injunction, my lords. Page 89, the last sentence, 4 lines from the bottom.
Yes.
It is pertinent to note that the plaintiff has not put her signature on the settlement deed dated 10/3/26. On the other hand, this is the premise on which it starts. Will not say an unconcluded agreement contents they wanted to hold it against me. But next sentence, at this stage, the defendants have produced any documents to show, to prove that the plaintiffs were dispossessed from the suit properties with due process of law. It will send principle of law that even a trespasser cannot be evicted without due process of law, hence balance of convenience. Will not this principle that a trespasser cannot be evicted has already crossed miles after this principle was laid down in Ramegowda's case in 1996. But nonetheless, not this is all what has been stated. There is no reasoning.
At this stage, defendants have produced any documents to prove that plaintiffs were
Lords,
dispossessed.
Probably at this stage, defendants have not produced any document. Should have been what I could read from that is that this, my lords. Defendant have not
So
produced
please
any
come to the
documents.
appellate court's order. What did the appellate court?
Let's now kindly have a look at the appellate court's order at page 116.
112.
Page number 11, page 115, my lords, para 20.
I think you
Stand
can come to
corrected.
para 22.
Lords, para 20, I'll just read it, my lords. There is something.
Yes.
No doubt the defendants have produced some documents to show present electricity bills are paid by defendants. This itself is not a ground for defendants to say that they got possession. It is well established principle that person who seeks aid of the court to protect his rights must come with court with clean hands. A wrongdoer can't seek discretionary relief. I am not seeking any discretionary relief. I am only opposing it. Counsel for the defendants further argued that the plaintiff lodged complaint only before the police that defendants are carrying out the manufacturing business activity illegally. The plaintiff evidence also shows that the defendants are carrying the business in the suit properties, premises in the night times illegally. Therefore, he has strongly contended that plaintiff is not in possession of the property. When plaintiff is not in possession of the property, plaintiffs to restrain the illegally interfering with business activities is not correct. On careful perusal of the plaintiff evidence, it is clear that the allegation of the plaintiff is that the defendants are carrying out business in the night times when the plaintiff is not available in the premises. Plaintiff has never said in the plaint that the defendants already took management and they are running the business. It's only on allegation by the plaintiff that during the night hours, the defendants were illegally manufacturing mineral water bottles. Even assuming the plaintiff has lodged a complaint before police saying the defendants are illegally carrying business and illegally they are purifying water, that itself is not a ground to say defendants are in exclusive possession of the suit property. At this stage, it is relevant to say wrongdoer can't seek the civil court aid to protect his wrongful possession. To that extent, the law is very clear. At this stage, it's also necessary to say a trespasser can protect his possession when his possession is settled. That is that to that extent, it is necessary to rewrite the Honorable Supreme Court decision. Lords, I'll skip this portion and come to page 118.
No. What are the documents the plaintiff has relied on to say that he's in
Only
possession of
there
the-
are 4 documents produced by them, Lords.
What
Lords,
are
can
they?
I just say this, Lords? I'll produce the entire set of documents. I understand because I don't want to handicap myself in submitting, Lords. What are the documents? I'll file a compilation of all the documents produced by us and produced by them tomorrow itself. Because I told them.
No,
that
I have a translated copy. I will produce it.
No,
There are
all
2
the
documents.
documents produced by the
Those are
plaintiff.
only
If he
important
wants to argue the matter, I have no difficulty. I can argue towards in relation to the court question. Lords, I said I'll make available the documents only to show that other than the MOU and certain payments having been made, nothing is produced to show that he has got either the ability to carry out the manufacturing activities legally by means of a trade license or a license or otherwise, nor does he have a GST registration to say that he is
That-
carrying out manufacturing activity this tomorrow, my lords.
Yes, they are not clear. They have to tomorrow.
Yeah.
27th, my lords. That's 26th is a holiday.
Left.
Case number 17.
Documents been filed ready, madam.
But
Impugned demand is at page 30 minutes. Impugned demand at page 30 under the Electricity Act is raised by ESCOM minutes, calling on me to pay to pay security deposit.
17.
Page 30, please minutes, item 17.
No, page number
Page 30 minutes,
30.
30 at 31. When I applied minutes for additional load in respect of this meter, additional electricity load, a demand is raised minutes on me calling on me to pay security deposit. Lords, section 47(5) mandates that ESCOM cannot make a demand for security deposit where I'm willing to take the electricity under a prepaid meter. In respect of this very meter, when my predecessor in interest had applied, and my lords, a similar demand was made, learned single judge, division bench, and my lords, Honorable Supreme Court struck down the demand. ESCOM said, my lords, that we don't have prepaid meter, we can't grant it. So learned single judge, my lords, made an arrangement where the electricity based on the average usage was collected in advance. And my lords, I was to pay based on their billing based on that average usage. That arrangement has remained in force since I succeeded to the meter. Now, my lords, I've invested 100 crores to expand the capacity of my plant. And I make an application, my lords, in March or April.
It is at earlier order.
Please, my lords. Annexure B, page 33. In 2015, this was of course by my predecessor in interest, my lords. Your lordships may kindly come to page 35 minutes. Your lordship, see, my lords, para 3, learned counsel for petition.
Let's annexure L and L1 they have submitted. We'll consider that in the light of the said judgment.
Today it may be too, my lords, I submitted that in June. I have a statutory right. Your lordships have recognized it.
In a time
They
bound
raised a
manner.
demand in March. I've invested 100 crores, my lords.
Within 1 week.
My,
2 weeks.
No, but why can't there be a positive direction?
We need to check whether the availability of smart meters, I mean prepaid meters is available for HT connection. That is the
that
feasibility.
issue was
Otherwise
settled in
also-
2015. This is the difficulty. Lordships kindly see
No,
the
now it
judgment.
is- now
This
it
was
is-
the same objection raised
No,
in
in that
2015.
case, no.
Now, my
What I'm
lords.
saying is, instead of this, considering the representations, again, they coming back, you can get that instruction. What, no,
Please,
what
my
he
lords.
wants, 1 minute. What he wants, he has stated so in his affidavit,
Please.
in this petition. So whether you can do it or not, it's only, no, as per the earlier arrangement made by the court in this WP number 13836 of 2015,
Please.
there can't be any objection for you.
Either one of them, my lords. Either we will have to provide with the prepaid meter or in advance we need to collect the charges.
Either
Either one
ways.
of them, we will consider
I
it, my
will,
lords,
I will say, either of you do it.
in the light of the said judgment.
Very well.
If it is
Can't say that,
operating in
there
I
the
have
should be
no
one.
objection to that.
So I'll say, in the light of it, if you have a what is that?
prepaid meter.
A prepaid meter is there, that is otherwise as per the order passed in WP number 13836.
Absolutely no difficulty.
In the light of the said
Absolutely no difficulty with that arrangement.
Come. The petitioner, the writ petition is filing the following prayer. The electricity connection to the plant is registered under RR number KEHT1, transferred to the name of the petitioner in March 2021. The said plant was originally operated by Vijaya Steels Limited, which held the electricity connection under the same RR number and had paid a security deposit of rupees 1,92 lakhs 4,018 plus additional security deposit of 25 lakhs aggregating to rupees 2 crore 17 lakhs 4,018. Bescom has issued successive demands to the Vijaya Steels Limited for additional security deposit. They challenged the same before the Consumer Redressal Forum, which rejected the complaint on 22/11/2014. Agreed thereby. They filed WP number 13836 of 2015 before this court. During the pendency of the writ petition, VSL submitted that it was prepared to take power supply through a prepayment meter, thereby invoking the protection of section 47(5) of the Electricity Act. That writ petition was disposed of by order dated 5/6/2015, directing the Bescom to supply electricity by collecting approximately monthly charges in advance without insisting for any security deposit, to adjust the existing security deposit paid by VSL towards energy charges, and to provide a prepayment meter to the company. The court has further directed that the said arrangement would remain in place until the prepayment meter is installed by respondent Bescom. Against that, a writ appeal is filed, that is writ appeal number 6090/6091 of 2017. That appeal was dismissed on 24/7/2018, confirming the order passed by the learned single judge. Against that, they preferred SLP number 9398 of 2020, and that also came to be dismissed by order dated 29/8/2022. Now it is a grievance of the petitioner when the petitioner wanted an additional load. Again, the respondents have come up with the same demand to pay the security deposit. It is submitted that in the light of the earlier orders which had attained finality, as the matters were carried till Supreme Court, the respondents cannot insist for the security deposit. They have to continue as per the arrangement made by the court in WP number
3836 of 2015.
WP number 13836 of 2015 dated 5th June 2015. Land Council representing the respondents submits that the petitioner has given the representation dated
29/6/2026.
29/6/2026. Now they have to look into the same. If the prepaid meters are available, they'll be providing the same, or else they will abide by the order dated 5th June 2020, 2015. Considering the submission of the Land Council, considering the submissions made on behalf of both the parties, this court is passing the following order: the writ petition is disposed of, directing the respondents to consider the case of the petitioner. And the respondents are directed to provide the additional
Electricity load.
electricity load,
Please.
either by providing a prepaid meter, or as per the arrangement made by the coordinate bench of this court dated 5th June 2025 in WP number 13836 of 2015.
Lord, may kindly consider quashing the demand, my lords, at annexure.
Consequently, the demand notice stated so and so is
So far as the demand is considered.
Only
There
so
are
far.
other,
notice is quashed as far as the demand for
Additional
the
security deposit charges.
security deposit is
and all
concerned.
other conditions remain.
Of course, we'll comply.
Yes.
Grateful.
Delete the name of Mr. Devraju. For respondent, Mr. Likita Prakash. Yes.
I'm obliged.
May permit me to file wakalat. Please.
Bill number 18.
Petitioner in this case, this matter had come up before your lordship on 20th.
Uh-huh.
I am the owner of the property, scheduled property mentioned in the writ petition.
Where is the prayer?
Prayer, I am seeking a writ of mandamus directing the authorities to restore the electricity. I am not conducting any industry in the plot. I am not an industrialist. I have only dug 2 bore wells and I am supplying water to 2 to 3
What are your
residential apartments. That's all.
Instructions.
And today they have furnished 2 papers. It does not relate to me at all. It relates to one Manjunatha dyeing works located. Manjunatha dyeing works have nothing to do with them. Their situation is entirely different. It is a mischievous act on the part of the elected, this one.
It is not an mischievous, as allegations made, that where the pollution control board inspected the spot, pollution control board inspected the spot, and where that it isn't find that so far that without permission, that they are doing a business, the industry. Not there that closure order was issued. In pursuant to the closure order,
Please pass on that.
That
Take
I'll
that,
place.
Code Officer.
I place it.
I have not received any notice neither from the pollution board nor from the KEB. Abruptly, my disconnection has taken place.
This is
I have nothing to do with
February
that.
2026.
Located at number 470 Lakshmi Layout, Main Road. What is the address?
Manjunatha, subject your lordship may kindly say. Manjunatha dyeing works located at number 470. I have nothing to do with them.
No, where is the premises you are referring to?
My premises, I am referring to.
Restore electricity connection to the petitioner's property situated at 12/180/2
Yes,
so
yes.
layout bearing so and so.
Yes, madam.
Failing with the jurisdiction of so and so.
Yes, yes, madam.
Let that.
The scheduled property itself, your lordship may kindly see, the location is entirely different. And what they are producing is a pollution control board notice issued to one Manjunatha dyeing works located. I have nothing to do with them. I am not doing any industry.
Lakshmi Main Road, Micro Layout, same
Yes.
address.
Mine is feeds Baikal at Begur village.
Number 12 oblique.
Number
80
12
oblique
oblique 180 bar 2.
No, this appears to be address is different.
That RR number, that it is not indifferent, I will place it on record.
And
entire
then
record,
kindly
what
see-
it is
kindly
there so
see,
far, that
Your Lordship-
including photographs is the premises.
Kind-
Here that it is a pollution control board order itself, that RR number discloses, that in that.
Notice.
What is the meter number?
No, notice,
Meter
noti-
number may
subject,
kindly
subject, subject code ನೋಡ್ಬೋದು. Notice issued to whom, your lordship may kindly say. Shri Manjunatha Dyeing Works located at number.
Forget about it. We are
Ah.
there. Electricity board is concerned with the meter. What
Meter,
is the
that's
meter
all.
number?
Pollution
Meter,
control board
meter,
order.
Bescom RR number unit 8S L1 56694. Now kindly see
Where do you
the
get that?
read papers.
That the
read pa-
pollution control board order.
Has been assigned RR number.
Yes.
So and so. And where is the RR number in this?
I have produced the receipt at annexure E, your lordship may kindly see at page 37.
The unit is
37.
8SL1, same number.
Same number is there. I'm not running an industry. How can they make use of my number? I am not running an industry. Your lordship may kindly see in
Please
whose
solve
name,
that.
Place it on
in
record.
whose,
I will place it on record.
in whose name this, the registration is there, kindly see it.
Then
It
counsel
stands
for
in the name of the
respondent
petitioner.
submits that. Then counsel for the respondent submits that. The pollution control board has passed an order. By virtue of that, they have disconnected the power supply. Then counsel for the petitioner submits that he has nothing to do with the
I'll
said
file an
order
affidavit.
passed by the pollution control board. And even the names that are mentioned in the said order also are unconnected with the petitioner. The BESCOM, which are the council appearing for the BESCOM, shall come up with detailed objections, placing all the relevant documents. When can you file?
Within a week that I'll place.
Yes.
That may Monday,
Madam,
next Monday.
your lordship may kindly till then, let them restore, because this is water which I am supplying to essential water supply to apartment complex.
Let's this matter on 1st of September.
Much.
I have nothing to do. I am not,
We'll see
I am
on
filing an
first.
undertaking also to the court.
We'll
I am
see.
not an industrialist.
We'll see. Yes. And you please serve it in advance so that if any
I'll serve.
rejoinder and all they want to file, they'll
That
file.
I'll serve.
The petitioner serve the same. The respondent shall serve the objections on the counsel for the petitioner by 27th of July. And by the next date of hearing, if any reply to that, that can be filed. Yes.
Grateful.
I appear for petitioner in this case. This is the defendant's petition, my lord. The judgment and decree passed by the trial court, the petitioner has questioned before this on the court, suit for recovery of money filed by the plaintiff. That is the respondent here in this case, please.
Yes, how much you're going to deposit?
My lord, I'm
Without depositing, nothing will not go in this.
25%.
How can it be 25%?
My lord,
Usual
is it-
rule is 50%. You pay 50%, I'll stay the proceedings, or else no.
Yes.
The petition is before this court. Agreed with the judgment and decree passed in SC number 724 of 2023, dated 3rd July 2026, whereby the suit is decreed, holding that the plaintiff is entitled to recover a sum of rupees 1,80,000 with interest at 6% per annum from the date of petition till the date of realization. The land counsel for the petition submit that the court has failed to consider the case of the defendant and decreed the suit. Considering the submission, they shall be stay of all further proceedings on the condition that he shall deposit 50% of the amount within 4 weeks from the date of receipt of the copy of the order. Yes, next. Notice to the respondents and summons. Yes, 20.
So
No
kindly
hand
pass
summons
on.
because nothing is pending, just notice. Yes, 20.
Kindly pass on, my lord.
Pass
Serial.
over. Yes, next.
Serial number 21. Kindly pass on.
20 and 21 pass
20
over.
and 21.
Yes, pass over.
For the record.
kindly pass over.
Pass over. Yes,
My lords, may I have this matter by day of tomorrow.
which one?
22nd matter, my friend is seeking urgent. Pass over.
Day after tomorrow. Yes, 23.
The respondent in this matter.
Where is the counsel for the petitioner? Yes, Mrs. Matter on no representation for the petitioner. Counsel for the respondent is present. List it on 3rd of September. Yes,
Grateful.
Here for the petitioner. The application for rejection of claim which is dismissed
Yes.
without adverting to any of the reasons, my lord, why we pointed this out. This is a 20-acre of parcel of land in Rajaji Nagar, where, my lord, a huge construction of apartments already come up. Suit is
What is the suit for?
Suit is for injunction to restrain us from interfering with his possession of 20 acres of land. There are 2-3 things he says. He says it's SC/ST granted land. And therefore, if it is SC/ST granted land, then under the Prevention of Transfer of Certain Lands Act, you must file an application before Assistant Commissioner. The second he says is that there's a sale deed of 2008 itself, whereby you purchased this property for 320 crores. And I've not challenged that. And I filed a suit for injunction after so many years. We also raise the issue of limitation. The learned trial court does not answer any question. He simply goes on the question of what is cause of action. It's a disputed question of law and fact, and then dismisses my application.
Let's see your IA.
Yes, ma'am. Can I request my lord to kindly come to page 82, my lord?
Yes.
There are two. Suit is barred by law and does not disclose the material cause of action.
So according to you, there is no cause of action, number one.
There is no cause of action. Suit is barred by limitation, and claims of PTCL are not
How it
made.
is barred by limitation?
2008 is a sale deed from a company called GKW. As a matter of fact, this land was acquired by the government.
Now, who mentions about this PTCL Act?
He mentions in a sale deed. In his plane, he says it's granted land and he's an SC/ST.
That's the case of the plaintiff.
That's the case of the plaintiff. Therefore, we said if at all you have a claim, you have to go under the PTCL Act. You can't come and file a civil suit. That's the first point. The second, my lord, is even according to him, the erstwhile owner on GKW had sold this property for 320 crores. You not challenge the sale deed. And if you knew of the sale deed in 2008, you did not challenge it till 2024 when you filed the suit.
Now, please come to the order.
Yes, ma'am. May I request my lord to kindly come to the findings at page 42.
42.
42.
Mm.
Of course, again, the contentions are noticed. And your lordship may kindly see at para 9. Please see page 44, my lord, on top. I'm sorry, my lord has it. Right on top. Plaintiffs have contended.
Yes.
Plaintiffs have contended the sale deed executed by CITB, that is City Improvement Trust Board, the erstwhile to BDA, my lord. The sale deed from CITB in favor of GKW dated 17/4/65 is concocted and created one. Sale deed does not reveal about survey numbers, nature, mode of acquisition, and its boundaries. Mere mentioning site numbers not create ownership until unless land records having clear title, and title shall not be allowed. Present suit is primarily for permanent injunction to protect the plaintiff's possessory rights, which is squarely within the jurisdiction of this court. PTCL does not create a complete bar on the jurisdiction of civil courts to entertain suits relating to possession injunction. Core contention of defense is that the suit is barred by law and there is no cause of action. Suits of defense filed written statement. Plaintiffs have filed suit against defendants seeking the relief of permanent injunction. Then Order 7, Rule 11 is extracted fully. Then remedy under Order 7, Rule 11 is independent special remedy when the court is empowered to summarily dismiss the suit at the threshold without proceeding to record evidence, conducting a trial on the basis of evidence adduced. If it is satisfied, the action should be terminated on any of the grounds contained. Under Order 7, Rule 11, duties cast on the court to decide. Then what some judgments of the courts are extracted. And then not all that the court says at para 19.
Where is the consideration by the court on all the contentions raised by them? There is no consideration by the court at all.
Well, it is very premature.
No, they say that.
Trial
no,
should
no, no. They say
go
that
on.
it's
Evidence
barred
should be adduced.
by- No, they say that it's
Please.
barred by limitation. Whether it's barred by limitation or not, whether that issue can be decided by the court or not, should have been decided by the court. No, what is happening is in all these Order 7 rule petitions, standard 1, 2, 3, 4 judgments, and it's a question of fact and law, dismissed. That's what is happening in every case. Well, set aside this order. We'll ask the court to decide it on the merits of it.
Yeah, please, on the merits,
Yes.
it may be decided, please.
On this application may be restored.
Agreed with her. Orders passed on 9 number 3. Filed under Order 7 Rule 11. Seeking rejection of the plaint. The defendant is before this court. Respondent herein has filed a suit seeking injunction. The defendants have filed an application Order 7 Rule 11 stating that the suit is barred by limitation. The property falls under the PTCL.
That's a claim of the plaintiff.
It's a case of the,
Plaintiff.
as it's a case of the plaintiff, that it's a property, there is
But
a,
there is no bar to file this.
no, that is their contention.
Please.
Under the, it's a prohibition of transfer of certain land, the scheduled caste and scheduled tribes, prohibition of transfer of certain lands Act 1978. Further, the sale deed is of the year 2008, which is
First is
questioned,
1965, no, then 2008.
1965, 2008, and thereafter, the suit is filed in the year 2024. The suit is barred by limitation, and it's their case that the cause of action, there is no cause of action for filing the suit. The trial court, by order impugned, had dismissed the application, observing that all the cause of action is a mixed question of fact and law. And at this juncture, the court cannot discuss nor go to the other documents produced by the defendants. And while perusing the plaint and plain document, the court did not find any reasons to reject the plaint. Further, the court is empowered to deal with the matter, though it falls under the PTCL Act. Then the senior counsel representing the counsel for the petitioner submits that when several contentions are raised by the defendant, there is no consideration, there is no finding by the court, by the trial court on all the issues that are raised. It is submitted that in a mechanical manner, relying on certain judgments, the court had dismissed the application and there is no, dismissed the IA and there is no application of mine. Next parallel, and counsel appearing for the respondent submits that the court has rightly considered and passed an order and there are no grounds to interfere. As at the threshold, all these questions of disputed questions of fact cannot be decided by the court. That can only be decided after a full-fledged trial and rightly dismissed ex para. Having the learning call of the petition, the consult the respondent, peruse the material on record. As many as 4 grounds are raised by the defendant. This court has perused the order. On the face of it, it discloses that there is no consideration of the grounds that are raised by the defendant. The court, when an application is filed under order 7 Rule 11, court has to consider the same on the merits of it and in a mechanical manner, like how this order is passed. The court cannot dismiss the application. In the considered opinion of the court has failed to consider the grounds taken by the defendant. In that view of the matter, the order impugned so and so is set aside and the matter is remanded to the trial court and the trial court shall consider the application in the light of the grounds raised by the defendant.
Grateful.
Respondent in this case.
Yes.
Press time, my lord. Senior is not well. He's admitted to hospital. I informed other side also.
2
weeks time, my lord.
27th, your lord.
27th.
In the meantime, stay may kindly be granted because. the
Without hearing it, I will not grant stay.
Trial court matter is listed on 18th, my lord. Matter has already been heard and the connected matter is also ordered to be listed.
If I have to grant stay, I have to hear you, I have to convince myself, then only I'll grant. Because matter is urgent, I'll not grant stay. It's just 27th.
27th.
Yes, list on 27th. Yes, next.
I've kept the affidavit ready, please, my lord. My lord had directed me to file an affidavit 8 months' time.
Take that.
Well,
No, only one statement which I would like to make is my advance of 3,50,000 is there with them.
I submit that I voluntarily surrendered the position on or before 24 and I shall
Well,
pay up to the date of surrender, subject to the respondent refunding rupees 3,50,000, being the interest-free refundable security to me. I shall not sublet underlet the scheduled property.
my lord, one humble submission, my lord, regarding the refunding of rupees 3,50,000, which is an advance amount. I don't have any knowledge about
I am
they
extremely
have
sorry.
already
realize that amount to the arrears or not, I have to take instructions from the respondent, my lord.
Tomorrow,
Kindly, my lord.
tomorrow, in the first list.
My lord, and moreover, the on last date of hearing, 6 months has been, for 6 months has been directed, my lord.
The Lord said
Now-
8 months.
Who has directed you 6 months? Your client?
No, my lord. This honorable court has directed to undertake.
Okay, I told you,
Yes,
2 months doesn't matter. Yes, tomorrow,
Tomorrow, my
get
lord.
instructions.
Great, I will file the memo of calculation.
In the first list itself, please. Below.
First list.
Grateful, my lord.
Interim order was there, it can be extended.
Huh?
Interim order was there.
Interim order is not extended on the last date of
it is not
hearing.
In you, you're not going to do anything. You want to
Please.
settle it?
Please,
Yes, tomorrow, interim order is extended. Yes.
Lord, I appear for the petitioner. There are two matters, Lord. May I request the,
In the meantime, let him complete, let him come. Yes.
Lord, this and the next matter are connected. May I request the Lordship to take the connected matter first?
Next matter,
Yeah.
28.
I appear in 27, but senior lead in 28. Both are almost identical.
Yes.
That suit is for declaration of title and injunction. We made an application for rejection of the plaint on the ground that on the face of it, on a reading of the plaint itself, it is barred by time. The cause of action which is given in the plaint, my lord, may I request your lordship to take the plaint, which is at page 34.
Yes.
There, the cause of action, your lordship, kindly take. The cause of action, para 11, at page
25/4,
38.
2014.
Yeah. The cause of action for the suit arose on 25/4/2014. Subsequently, on 2/9/20, when the defendants wanted to have illegally alienated the suit property to defendant number 3, pending litigation on 24/7/21 and 4/8/21, when the defendant number 3 tried to illegally interfere with peaceful possession of the suit property by the plaintiff, subsequently within the jurisdiction of this court. Now, my lord, kindly take the impugned order. The court virtually alters the cause of
What we
action
do
which is
is,
given in
what
the
we
plaint.
no, let us understand from your application. Where is your application?
Application, my lord, at page 45.
Yes. What are the grounds that are raised?
Yes. That is at para 2. I state that it was in the plaintiff's knowledge that Muddamma was the true owner of the suit property bearing survey number 40 to an extent of 2 acres 13 gunta, as she had inherited from her father, late Nagappa Reddy, who was the son of Muni Reddy. Nagappa Reddy was an only child, and he had inherited it from his father, Muni Reddy. Muddamma was the true and legal owner of the suit property. I state that Muddamma had filed an application before the concerned revenue authority for mutation of the revenue record to reflect her name as the owner in possession of the suit property. Muddamma's name was mutated as the owner and possessor of suit property by the order of the
What is this
Tahsildar
order?
on 25/4/2014.
Oh, that is the date they are saying.
That is the date on which they cause of action. That followed by along with the plaintiff documents, the plaintiff had produced it. May I just pass on the plaintiff documents? In the plaintiff document,
Hmm.
which is at page 20, page 13, is the order passed by the Deputy Commissioner, which is on 25/4/2014, wherein the claim of this present plaintiff was rejected, challenging the entry made in favor of Muddamma was rejected. The revision petition came to be dismissed. This is the date which the plaintiff says it gave him the cause of action.
Yes.
After that, he files a suit for injunction also. That suit for injunction was ex parte decreed in his favor, because by that time, this Muddamma had already sold the property in favor of the third defendant.
No, plaintiff files a suit for injunction.
Plaintiff filed a suit for injunction.
What is that OS number?
That is, Lord, OS
219 of 2014.
219.
of 2014.
Hmm.
By that time, the defendant wanted to had sold the property on 2/9/20 in favor of third defendant. After the sale by an ex parte decree, it was decreed in 2021.
Hmm. Yes.
So this is on the basis of this Deputy Commissioner's order, where rejecting entry in his name,
he traces the cause of action. Now, if your lordship look at the impugned order, the reason starts from page 25, but the relevant portion at paragraph 10 at page 30.
Paragraph 10.
Yes. However, in the entire plate, para 9 has an important role in considering the present application. And in the said paragraph, plaintiff has stated that on 24/7/21, when the plaintiff was not in the suit premises, the defendant number 3 with some rowdy elements had entered into suit property, threatened the workers with dire consequences, said that he has purchased the suit property from defendant number 1 and 2, and forcibly wanted to take possession of the scheduled property. Further, again on 4/8/21, at 11 a.m., the defendants came near the suit property, tried to trespass the plaintiff's property. Hence, these events drove the plaintiff to file the present suit for declaration and injunction. Defendant number 3 has relied upon cause of action as stated by the plaintiff. As per plaintiff, the cause of action for the suit arose on 25/4/2014. First date of accrual of the right of sue has to be considered, as the plaintiff has not filed the suit within 3 years from the date 25/4/2014. Suit of the plaintiff is barred by limitation. Since the plaintiff has filed a suit for declaration, Article 58 of the Limitation Act has to be considered. As per Article 58 of the limitation, to obtain declaration, period of limitation is 3 years, and time from which period time begins to run is right to sue that first accrued. In the instant case, on going through the plain pleading, right to sue first accrued on 24/7/21, when the defendants interfered with the plaintiff's possession and stated that he has purchased the scheduled property from defendant number 1 and 2. Plaintiff has stated that cause of action for the suit
So
arose on
when you're read as defendant number,
the defendant number 3.
when did you purchase the property?
I purchased the property on 9/9 on 2/9/20. 9/9/2020.
9/9.
2020.
Hmm.
But once the plaintiff, ultimately,
No, you are the defendant in his suit for injunction.
I am the third defendant. Defendant number 1 and 2 are my vendors. So he is
No,
claiming.
you were also arraigned in that injunction suit.
Yes, yes. No, not in that suit. In the suit for injunction, I am not a party.
Only defendant number 1 and 2 in
1
the
and
suit.
2 are parties. In the
And
suit
they have
for.
filed another CRP.
What?
Is it?
Pardon?
No, my lord. That is another.
Defendant number 3, my lord, has filed it.
Yes.
Now, defendant number 1 and 2 and 3, against all of them, the suit is filed for declaration of title. So the court, my lord, once the cause of action arises, the question of now the second time cause of action arising and thereafter the raising, my lord, will not arise, is the view taken by the Supreme Court when the first cause of action arises.
Take that. Which para in the first judgment?
Lord, the first judgment of 2025, para 24. Para 24 in the first judgment 2025 SCC online. There is no dispute to the fact that limitation for filing the suit falls under Article 58 of the schedule to that, wherein the limitation prescribed is 3 years. It may be pertinent to note that the limitation of 3 years is from the date when the cause of action first arose. So according to plaintiff's case, the cause of action first arose on 4/2/2014. Therefore, the limitation would end on 4/2/2017. However, even if the limitation is calculated from the date of knowledge of the will or the codicil, it would run from the first week of November 2014 and would end in the first week of November 2017. Suit admittedly was instituted on 21/11/2017, much beyond the first week of November 2017. As such, is apparently barred by limitation, for which neither any defense is required to be looked into, nor any evidence in support is needed to be adduced. Section 3 of the Act contemplates that every suit instituted after the period prescribed under that shall be dismissed even if limitation has not been set up as a defense. The aforesaid provision is of a mandatory nature, cannot be ignored by the courts even if not pleaded or argued by the defense. It is obligatory upon the court to dismiss the suit if it is on the face of it barred by limitation. The aforesaid provision has been enacted for public good and to give quietus to a remedy after lapse of a particular period as a matter of public policy, though without extinguishing the right in certain cases. Therefore, once a limitation prescribed for instituting a cause of action expires, and even if limitation is not set up as a defense, it obliges the court to dismiss the suit as barred by limitation. In the present case, plaintiff not only categorically stated that he acquired knowledge of the will and the codicil in the first week of November 2014, but also that the cause of action of the suit first arose on 4/2/2014 and lastly on 21/10/2014. Suit was filed on 21/11/2017. As such, on the own averments of the plaintiff, suit was instituted beyond limitation of the order, so on, so attracting order 7, so on. So then the
State of Tripura.
yeah, then my lord, the Mukunda Bharat Trust is there, the judgment, which is at page
74.
74,
What is the paragraph number?
para 25. Continuing further with the plea of limitation, courts below have held that the question of the suit being barred by limitation can be decided at the time of trial, as the question of limitation is a mixed question of law and fact. Though the question of limitation generally is a mixed question of law and fact, when upon meaningful reading of the plain, court can come to a conclusion that under the given circumstance, after dissecting the vices of clever drafting, creating an illusion of cause of action, the suit is hopelessly barred and the plain can be rejected under Order 7, Rule 11. In the present case, we have already held that 2/3/2007 is a fictional date. Then below para 40 also.
Yes.
At this juncture, we wish to observe that we are not unmindful of the position of the law, that limitation is a mixed question of fact and law, and the question of rejecting the plaint on that score has to be decided after weighing evidence on record. However, in cases like this, where it is glaring from the plaint averment that the suit is hopelessly barred by limitation, court should not be hesitant in granting the relief and drive the parties back to the trial court. We again place it on record. This is not a case where any forgery or fabrication is committed, which had recently come to the knowledge of the plaintiff. Rather, the plaintiff and his predecessor did not take any steps to assert the title and rights in time. The alleged cause of action is also found in a creation of fiction. Then, my lord, this Sri Vidya Surya, page 19.
Which one?
Page 19. Para 11.1 at page 33. Para 11.1 as held by this court at page 33. In a Katanav decision right from 77 that a mere
Judgment.
page Surya blood that starts from
Sri Surya Developers. Starts
page
at
19.
Relevant is it?
33.
Yes.
Para 11.1 as held by this court in a Katanav decision right from 1977 that a mere clever drafting would not permit the plaintiff to make the suit maintainable, which otherwise would not be maintainable and are barred by law. It has been consistently held by this court that if clever drafting of the plaint has created the illusion of a cause of action, the court will nip it in the bud at the earliest so that bogus litigation will come to an end at earlier stage. In T. Arvindam versus Satyapal, it is observed held as under. We have not the slightest hesitation in condemning the petitioner for the gross abuse of the process of the court repeatedly and unrepentantly resorted to. From the statement of the facts found in the judgment of the High Court, it is perfectly plain that the suit now pending before First Municipal Court, Bangalore, is a flagrant misuse of the mercies of the law in receiving plaints. The learned Munsif must remember that if on a meaningful, not formal reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, he should exercise his power under Order 7, Rule 11 CPC, taking care to see that the ground mentioned therein is fulfilled. And if clever drafting has created the illusion of a cause of action, nip it in the bud at the first hearing by examining the party searchingly under Order 10 CPC. An activist judge is the answer to irresponsible lawsuits. In Ram Singh versus Gram Panchayat so and so, this court has observed and held that when the suit is barred by any law, plaintiff cannot be allowed to circumvent this provision by means of clever drafting so as to avoid mention of those circumstances.
Yes.
Lord, similar is the other judgment. Now, if your lordship look at the plaintiff,
Yes.
page, it starts from page 32.
Yes.
Para 5, my lord, your lordship may go to para 5
Yes.
at page 34. Plaintiff submits on 28/9/2012, plaintiff went to the Tahsildar office to get the RTC for his bona fide use. And at that point of time, plaintiff came to know that in the RTC at column number 9, the name of the second defendant's father has been defected instead of the plaintiff's name. Second defendant is my vendor. Immediately, the plaintiff got the mutation and came to know that the second defendant has filed a frivolous appeal before the State Commissioner Tahsildar by suppressing material facts, obtained an ex parte order, got the RTC changed in her name to entire extent of 2 acre 12 guntas. Copy of the RTC is produced so and so. Plaintiff submit that immediately the plaintiff contacted his counsel, applied for the copies of the revision petition and the appeal order, agreed with the said order passed by the Assistant Commissioner Tahsildar. Plaintiff has already filed a revision petition before the Deputy Commissioner has obtained stay of the said order which was pending consideration in revision petition number so and so. Later, the Deputy Commissioner had dismissed. The dismissal date is 25/4/2014. Plaintiff submit that pursuant to the order passed by the Deputy Commissioner in revision petition, filed by the plaintiff was dismissed, for which the plaintiff had filed writ petition number so and so, which is pending consideration in the Honorable High Court of Karnataka. Plaintiff further submit that the plaintiff subsequently to had filed suit for injunction in OS 219/2014 on the file of Principal Civil Judge Junior Division Bangalore Rural against defendants number 1 and 2. Said suit of the defendants were served and placed ex parte. Said suit was decreed in favor of the plaintiff, and also defendants 1 and 2 have been
Thereafter,
restrained.
no steps were taken by you.
Yeah, that suit, my lord, is decreed on 25/3/21.
No steps were taken by either of the defendants.
No, that was by that time they had already sold, and I was not a party to that particular proceeding.
Yes.
The plaintiff submits that in order to para 8, order to forego any further litigation during pendency of WP number so and so, defendant number 1 and 2 have alienated the suit property to defendant number 3 under registered sale deed dated 2/9/2020. This is sale deed in my favor. It is further submitted that the said alienation is during the pendency of the civil litigation for injunction, also during the pendency of the writ petition before the Honorable High Court of Karnataka, which transaction is void transaction and the sale deed is executed by defendant number 1 and 2 in favor of defendant number 3, not binding on this plaintiff. The copy of the pendency of the writ petition is produced here with a document number so on. That being the case, on 24/7/21, when this plaintiff was not in suit premises, the third defendant with some of the roadie elements has straightaway entered into suit property and threatened the workers with dire consequences, said that the suit property belongs to him. He has purchased the same from defendant number 1 and 2, forcibly wanted to take possession of the property, which was registered by the workers, and immediately same was brought to the knowledge of the plaintiff, who immediately brought to the notice of jurisdictional police, who were helpless due to the immense pressure that was put on the police by the defendant. The plaintiff was able to resist the illegal act of the defendants through the help of the neighbors and friends. While returning, the defendant stated that they would dispossess the plaintiff illegally. That being the case of jurisdictional police, instead of taking action against defendant, they summoned the plaintiff to the police station based on illegal complaint given by the defendant and warned the plaintiff and insisted the plaintiff not to interfere with the defendant, so on. Then, my lord, he says in para 11, cause of action for the suit arose on 25/4/2014, subsequently on 2/9/20. Defendants 1 and 2 others. He does not confine the cause of action only to the date on which this 24/7/21 incident happened. So the cause of action, once he says, arises on the date when the Deputy Commissioner rejected the revision petition by which the entry was made in the name of my vendor. On a reading of the plaintiff itself, the lower court cannot say the cause of action is on 24/7/21, not on 25/4/2014. Therefore, my lord, it is my submission that
No, why there are two writ petitions?
But
Two writ petitions.
two below, because one portion of the land I purchased, another portion is,
No.
Same person.
No.
That's what
No,
my
just
learned senior
senior
is
has
arguing.
argued 28.
28 relates to 1 acre, 12 guntas, my lords, the original owner.
another sold to Gangappa.
That same owner, that's the plaintiff, my lord, that sold 1 acre in favor of the plaintiff in serial number 27.
Serial number, give that. He filed two different sources.
That's two different sources.
One is by Chickbait Housing Cooperative Society, who has purchased 1 acre of land from me, my lord, in 2005.
But the averments are all the same.
Let's see that.
Lords, the plaint in serial number 27, your lordships would get at page 32.
This is OS number 1811102021.
Yes, my lords. That's by Bangalore.
No, the defendant, no, the defendant in the
Same.
other suit is also a party to this.
Yes, because my lords, the defendant here in this suit, I am defendant number 4. In the other suit, which my learned senior argued, I am defendant number 3. I am only one purchaser who had purchased 2 acres, 12 guntas. The plaintiff's case is the original plaintiff, I mean, in serial number 27, the extent of land is 2 acres, 12 guntas. 1 acre is sold to my learned friends. That is a Bangalore City Chickpet thing. So for 1 acre, one suit is filed. For 1 acre, 12 guntas, other suit is filed. But the averments are all same, identical. There is no change at all. Lords, if your lordship sees in this, the plaint starts at my lord's page number 32.
No, this Bangalore City Chickpet House
Yes, my
Building
lord.
Society, come to their plaint. Let's see.
Pardon me.
Come to the plaint in this case.
Plaint is 32, my lords. Page, running page 32. Lords,
When did they purchase the property?
they purchased on 7/1/2005.
2004.
Lords, Bangalore City is
First it was sold to Gangappa, my lord. Then Gangappa sold to, me, my lord. 1 acre he sold to me in 2005, my lord, January.
7/1/2005. Lords, Bangalore, if your lordships have the plain,
Yes, let's see that.
page 32, my lords. The plaintiff purchases from one Gangappa, 1 acre, my lords. Gangappa in turn had purchased it from one Krishnamurthy on 2/4/2004. Krishnamurthy is the plaintiff in in serial number, the other suit which your lordship my learned friend. So Krishnamurthy sold.
In this plaint also, she narrates about all those.
Same, my lords, please come. It's nothing else is there. If your lordship kindly come, my lords, except saying plaintiff, they say plaintiff's vendor. That is Krishnamurthy.
But they narrate all these issues.
The order also is the same. Your lordship kindly come to para 5, my lords.
Yes.
It says the plaintiff submits at page 34. The first defendant's vendor, subsequent to conversion of the property, had alienated 1 acre of land in survey number so and so in favor of first defendant under a registered sale deed dated 2/4/2004. It's further submitted first defendant had alienated the same in favor of this plaintiff and put the plaintiff. The plaintiff submits two defendants 2 to 3 is said to have filed an RRTC case and got the kata of the entire survey number 40 transferred in their favor, in which neither the original vendor of the first defendant nor the first defendant were made as parties in the said proceedings. It is further submitted first defendant's vendor agreed by the said order passed by the Assistant Commissioner Tahsildar. The plaintiff had already filed a revision petition before Deputy Commissioner and had obtained the stay of the said order, and later the said appeal also came to be dismissed. Plaintiff says submits that agreed by the order passed by the said revisional authority, revision number so and so, filed by the first defendant's vendor, is said to have filed a writ petition in WP number 24001 of 2014, which is pending consideration. Then next para 8, its repetition. That being the case, on 27/4/21, when the plaintiff was not in suit premises, defendant with some rowdy elements, same minutes. Then para 10, there's nothing different. Para 10.
Something about dismiss for default here at page 7. Para 7.
Para 7 minutes.
End of para 7.
The plaintiffs had also filed a suit for injunction in respect of property in OS number dash of, which is said to have been dismissed for default.
What is this dash?
That only the
OS
plaintiff.
number they had filed earlier, which was dismissed for default, my lord, that is not
That's-
mentioned.
Yes.
That is their case.
Hmm.
Then, my lord, please see the para 10.
Yes.
Same thing. The cause of action for the suit arose on 25/4/2014 and subsequently on 2/9/2020 when the defendants 2 and 3 have illegally alienated the suit property to defendant number 4 pending litigation, and on 24/7/21 and 4/8/21 when defendant number 4 tried to illegally interfere with the peaceful. So, my lords, it's nothing is different except the same thing in both the suits. I am defendant number 3 in the other suit, here 4. They create the second cause of action is a created cause of action. 14 was the first time they themselves admit, 14 when they came to know. But my learned friend referred to all the judgments, the same thing, except, my lords, there's one latest judgment rendered by the Honorable Supreme Court in Asha Devi versus Arvind Kumar. This was rendered on 17th August, my lords. In that, if your lordship come to, this is also a case of rejection of plaint on limitation, my lords. Trial court and high court had rejected the applications. Para 6, if your lordship may kindly come in bottom, your lordships should get para page 3. Their lordships again considered the judgment in Mukundan's case, which my learned friend referred to, Mukund Bhavan Trust. Then, my lords, please come to para number 9, page 5. It starts with insofar as limitation, if your lordship sir. In the present case, we need only to look at para 17 of the plaint filed before the additional district and sessions judge Chengalpet 2 in OS number so and so, which brings forth the cause of action asserted by the plaintiff itself extracted herein below. Plaintiffs submit that the cause of action for the suit arose on 18/8/2014 when the plaintiffs had entered into 2 memorandum of joint venture agreements with defendant with respect to construction of 8 flats in vacant sites in plot number S4 and S7 at cost of plaintiffs. In August 2016, when plaintiffs had completed the construction of 8 flats, then they go on about communications. But please turn over, my lords, para 10. They go on giving communications between the plaintiff and defendant. Para 10.
Yes.
The cause of action as seen from the above, according to us, arose on the first communication cancelling the joint venture agreement dated 24/2016. The further communications between the appellant and the respondent only highlights the dispute arising from the cancellation and does not create a fresh cause of action in any event. The suit was filed in October 22, grossly delayed from the year 2016 itself. So, that's the first cause of action is what is relevant. That's the only submission so far as this is.
Kindly pass.
Pass. 230.
And petitioners are the same, lords. Both of us are same petitioners.
Yes.
Nice.
What is this maintainability? Let's see. No representation. This is matter on 16th of September.
Lord, I am filing memo along with the acknowledgement which is served to the trial court.
Take that. In both the matters.
Yes, ma'am.
No, it is referring to respondent number 2.
Yes, ma'am.
As per the cause list, you are yet to serve the notice to R2
I
This
have
is in
served
respect of R1.
R1, my lord. I'll serve R2 for
The
R2.
memo is filed. But it is already served on R1 at statement of objections filed by advocate for R1. And where is the question? I think it is some by mistake. It should have been R2.
It's my lord, sorry.
Lissus matter on tomorrow. Verify that.
Oh, my lord.
Lissus matter tomorrow. Yes.
And for the petitioner, Your Lordship, with respect, this is a plain rejection application which we had filed before the.
It's coming up for orders. What is this?
Already.
Non-furnishing
Yes.
of PF to issue notice to R2 to R11.
Your Lordship, some of the respondents are petitioners in the next matter, 32. And we've already filed a memo to dispense the notice.
When
to
was
other
it
parties.
filed? When was it ordered?
No, the memo is still pending, I believe, Your Lordship. Nonetheless, I'm filing another memo.
Take that.
Yes. The respondent number 1 is the contesting party in this, Your Lordship. The respondents 2 to 13, I
A
believe.
memo is filed stating that except respondent number 1, the other respondents are not former parties. Accordingly, notice to, how many are there?
More than 23, I believe. Your
Notice to R2 to
to 28, Your Lordship. 28.
Huh?
28.
Where do you get them? Not cause list here. The writ petition.
You're
It's not shown anybody in the cause title.
yeah. 13 to. You are Article 2.
Respondents 2 to 28.
Yes.
Dispense with. Yes. Look at it if interim order is there. Earlier granted is extended.
I may be heard. I may be heard on merits, Your Lordship.
We'll see. Yes. 30 is also connected to this.
Yes.
32 is connected, Lordship. Lordship has directed to serve the copy to R1, has served it, Lordship. They are the contested responded. They are
R1
not
is served.
Ah,
A
Lordship.
memo is filed stating
IA may be,
that as per the order passed by the court.
Lordship,
the-
IA may be considered, Lordship, for stay. For that reason, Lordship has issued a direction
R1.
to.
Notice is served on the council appearing for the R1. Accordingly, notice to R1 is held
Lordship,
sufficient. Yes.
Both the matters are
Yes.
connected.
I have to pass a order finally, not interim order.
Lordship, kindly, let's say this is the case, Lordship, there is a
No, I'm saying I'll pass the order
Yes,
finally.
Lordship. What's,
Yes,
I leave it on this honorable.
come to the order.
Come,
You appear for who?
that's it.
Respondents, may lord.
No wakalat is filed in 32.
32.
31 is already adjourned.
Lordship,
Yes, where is the impugned order?
implied order, Lordship will find them on page number.
What is the suit for?
It's suit for declaration and injunction, Lordship. The implied order start from page number 28, Lordship. My contention in 32 is, Lordship, that there's though they don't have any cause of actions. And the relevant portion, the discussion part is on page number 39, Lordship. Para number 14, the reasoning starts, Lordship. Without considering any of the contention, the court rely on the pleadings and stated that I have no right. Lordship, as a 711, Lordship, I have a limited scope to rely only on the pleadings and the documents, Lordship. And what I demonstrated before the trial court is, I'll just take this honorable court for a moment to the plain copy, Lordship. Page number 52 is the plain copy. Lordship is on reasoning, page number 4.
When this Nanjappa died?
He died in 1997, Lordship. Expired 1997, 17/12/1997. And their case is in 1992, he's executed the sale deed. Will in the
Not
favor
to
of.
sale deed, will.
No, will. He's going to sell it. And he has purchased the property in 1946, Lordship. And we purchased the property in 1981, my father and his brother. And my contention, Lordship, is that this particular property which they are saying it is sold it to other vendors immediately, Lordship. And subsequently it fell to my father in 1991, Lordship. 1981. Just sit down. Lordship. You wait, I'll do that.
No, all the records are in the name of the plaintiff.
It is on the name of defendants.
Defendant.
Yeah, petitioner before this honorable. Lordship, kindly appreciate, since there is no specific para of cause of action, I'll trouble this court to read the plaintiff amendments, Lordship.
When did you purchase?
The plaintiff amendment, Lordship.
When did you purchase?
We in 1981 we have purchased it, and since 1981 we are in the possession, Lordship. Even this court has decided the position.
When counsel the petitioner submits that,
But
they have
kindly,
filed an
the court has
application
decided the position, they said that-
seeking, they have filed an application seeking rejection of the plaint on the ground that the suit is barred by limitation. The property is purchased in the year 1981. And the petitioner, the plaintiff is seeking.
Even the possession is also decided by this court. We are in
My
possession.
lord, I've been made arraigned as a party in 32, serial number 32 as well, my lord. I undertake to file wakalat, my lord.
It is submitted that the suit is filed in the year 2020. The suit is miserably barred by limitation, and these aspects were not considered by the court. Considering the submission, they shall be stay of all further proceedings pursuant to the order dated. So,
Deeply aware. Lordship, it's a long pending matter. Any date may be given, will Lordship can dispose it of. Both the matters.
There's this matter on 22nd September.
File objections,
31
my
also
lord.
as well, Lordship.
Yes,
Will
next.
not serve the copies as well, my lord. I file objection.
Lordship, we serve the copy to the, in spite of that one, I'll serve one more copy.
Yes, 33.
I think for the respondent number 1, my lord, I undertake to file an wakalat on behalf of respondent number 1.
Respondent number?
1.
Land counsel submits that. He has instructions to file wakalata on behalf of R1.
My lord's interim order will be extended.
Interim order earlier granted is extended. At request of land counsel for the respondent number 1. This matter on 6th of October.
Much obliged.
Yes, 34.
Therefore, the petitioner, the lordships have permitted me to serve on the council representing the plaintiffs before the trial court. We have done that and I filed a memo. So,
The memo is filed.
Yes.
As per the order passed by this court, the petitioner served the notice on the council appearing for respondent 1 to 3 before the trial court, and a memo is filed in that regard. Accordingly, notice to R1 to R3 is held sufficient. Yes.
Let's, before I read the plaint, let's two averments. The
What is the
plaintiff's
suit for?
suit for partition and declaration to declare the registered sale deed executed by the defendant number 1 in the year 2012 in favor of defendant number 2 is not binding upon the plaintiffs. Plus plaintiff number 1 is the mother, 2 and 3 are the daughters. While the father is alive, plus this suit for partition is presented, which is not maintainable as settled. It's a well settled law. Plus, along with that,
Father has executed the sale deed.
correct. And while the father is alive, suit for partition as against the father is not maintainable.
What is the finding?
Your lordships will see a judgment is recorded. Reasons your lordships will see at page number 35. That there was an earlier suit. There was an earlier suit which is also for partition.
Where is that answered?
Please, Malaj.
Where is that answered? Your contention that during the lifetime of the father suit.
That is not at all taken into record, but it is a settled law. I have judgments Malaj to that.
I said,
Please.
where is your contention adverted to by the court?
It is not taken into consideration. Nevertheless, if your lordships will see, with respect,
When counsel for the petitioner submits that a suit is filed by the wife, by the daughters against the father seeking partition during his lifetime. and the same is not maintainable. This, the said contention raised with the petitioner was not at all answered by the court in the order impugned. Considering the same, there shall be stay of all further proceedings pursuant to the order dated so and so.
I'm so grateful.
Appearing for the petitioner in this matter, Your Lordship, the matter has been listed for orders today. The R6 is not a contesting party in this matter, Your Lordship.
Notice to R6 returned as unclaimed amounts to deemed service of notice. Yes. Ready?
Your Lordship, it may be at next week. I'm a little unwell today. I may.
Next week.
Grateful,
Yes.
Your Lordship.
Yes, 36.
And for the petitioner, on 4/7/2025 itself, an advocate has undertook to appear on behalf of. Therefore, notice to respond number 1 may not be required. So far as office note number 2.
Council so and so submits that. Priyanka MK.
MR, my lords.
Priyanka MR has instructions to file wakalat on behalf of R1 and R2. Last
We
time
have
also-
filed,
Yes.
my
Filed.
lords. We have filed it already.
Wakalat not because name is wrongly shown.
Name is wrongly shown, but we have
Priyanka
filed it
MR.
in the
Registry
counter,
is
my
directed
lords.
to reflect the name of the council for R1 and R2 as Priyanka MR. Yes, ready?
Ready, my
Yes.
lords.
Suit for partition filed by the respondents
Yes.
in respect of suitable properties, contending that they are the ancestral properties. I filed the written statement and also application contending that there was a registered
Come
partition.
to your IA application.
IA annexure D,
Page number.
page number 27.
Yes.
Suit is hit by subclass 5 of section 6 of the Hindu Succession Act. In view of registered partition between the family, even prior to 2004. That is the contention, para number 2, affidavit at page number 28. I submit that the plaintiff, suit of the plaintiff is hit by section subclass 5 of section 6, together with section 6(1)(c) of Hindu Succession Act. Plaintiff has made an amendment in the plaint that the suitable properties are the joint family properties and they are entitled for equal share in the properties. More importantly, plaintiffs have also.
Who are
made-
you?
And I am the, you will may kindly see page number 16. One Kenchavirappa is the
No, you're the purchaser of the property.
no, I am the family member. I am the family member. Kenchavirappa
That
is
family tree.
page number 16 may kindly see. They themselves produced. One Kenchavirappa is the propositors. Got 2 daughters, wives. Second wife, Marikinchamma, is the got 1 daughter, Jayamma. These plaintiffs and defendant, number 1 are the children of Jayamma.
What is this Devadasi?
Devadasi means
No,
without
she-
marriage.
My lords, may I appreciate the court with the facts? May I appreciate the court with the facts, my lords, as per plaint? My lords, this Kenchavirappa had 2 wives, my lords. He had few ancestral properties. Upon his death, it was succeeded by Satyamma, the first wife. She did not have any children. Later, she died intestate. Then the properties were supposed to be succeeded by Jayamma and her children. Jayamma was dead again. She has also died intestate. It was supposed to be succeeded by the 3 children. But what happened is, instead of succeeding by 3 children, it was directly the petitioner present. He is the first defendant. He has got the properties mutated in his name.
Who is he?
He is the son of Jayamma, my lords.
D1 Chandranna, one of the only son. There was a partition between defendants 1 and 2 in the year 2001. Thus, partition deed also challenged.
My lords, defendant.
Therefore, my contention was section 6 applies. Subclass 5 says that
According to the plaintiff.
it is the ancestral property.
Who is the plaintiff?
My lords,
Plaintiffs are the daughters of Jayamma.
Kenchamma and Saubhagyamma.
Kenchamma and Saubhagyamma are the
Are the
plaintiffs.
daughters of Jayamma.
Are the plaintiffs.
Plaintiffs, yes,
Please.
my lords.
You are the defendant.
Defendant number 1. Their contention
According to you, when was the partition?
2001
Between whom?
between defendants 1 and 2.
My lords,
And
defendant
according
number
to
1
them-
and 2 is husband and wife.
According to them, para number 3 may kindly be seen. Plaint. It is the ancestral property.
Where do you get that?
Page number 16 itself.
He submitted that the propositors of late Kencha Ramappa derived agriculture land from his ancestors, which are shown in below schedule. After his death, the suitful properties were omitted in the name of first wife Srimati Satyamma. After her death, the defendant number 1 got the suitful properties mutated in his name behind the back of plaintiffs. This is the averment. Therefore, even according to them, it is the ancestral property. Therefore, section 6 applies. Subclass 5. On that ground, I have filed the application. Reasoning of the trial court may kindly be seen. Page number 13. Trial court says section 16 applies.
You have entered into a partition deed with your wife.
Yes, madam.
And you call it a partition and hit by section 6.
Section 6(5). And the definition,
how can it be?
It defines only partition.
Where is your, is she a member of the joint family,
No,
your wife?
madam, she is not the joint
Then
family
in that
member.
case, how can it be a partition deed? How can you call it?
But you will ask me kindly appreciate my contention, madam.
It can't be appreciated.
Section 6(5).
They're entitled for they're entitled for partition, your sisters there, and you say that before 2006, you have partitioned the property among you and your wife. So it amounts to partition hit by that,
Insofar as
and that is saved by the amendment.
This property, in fact, is not the property of JMI. It is
That
the
is a
property of
different
an absolute
aspect.
property of defendant number 1.
That is a different aspect which will be dealt with by the court.
On merits.
To take shelter under 2006, this will not, you don't have a ground.
For a moment, Manali, you will ask me kindly see definition of partition under section 6. It says.
It will happen among whom?
Partition Act.
And,
yes, please come. Agreed with the order.
My lords, I'm filing my formal objections as well.
Agreed with the no objections are required in a CRP, that is settled law. Agreed with the order passed on I number 7 in OS number 46 of 2021, dated 10th December 2025 by the senior civil judge, Itinerary Court at Jagloor. The petitioner defendant is before this court. The respondents herein has filed a suit for partition. The respondents are the sisters. The defendant is the brother, and defendant number 2 is his wife. In the said suit, the defendant has filed an application under Order 7 to 11 seeking rejection of the plaint. According to him, the suit filed by according to the defendant, the suit filed with the plaintiff is hit by Section 6(5), read with Section 6(1)(c) of the Hindu Succession Act 2005. The plaint in the plaint it is stated that the defendant number 1 and 2 have entered into a partition deed dated 12/2/2021, and in the light of the in the light of the amended act, that is the Section 6(5) of the Hindu Succession Act, if any partition occurred prior to 12/12/2024, then no rights would accrue on account of the amendment to a Hindu women. Then the court, this is considering the said contentions raised by the defendant, the court had dismissed the application. The court has observed that The wife cannot be considered as a co-partner. Therefore, such partition constitutes any legal sanctity and then in the eye of law is to be determined only after full-fledged trial. On plain reading of the plaintiff, it cannot be said that suit is barred by law. The application appears to be an attempt to protract the proceedings and to delay the adjudication of the rights of the plaintiff. In spite of that, you are filing a CRP with that finding.
Another finding is that section 6 applies. That is not correct. Section 6 is not applicable. Even according to plaintiffs, it is ancestral property.
It should be this written. This has to be dismissed with cause.
My
And
lords, may I
accordingly-
make a submission? The present defendants are 80 years old, my lords, and the suit was filed in 2021. The defendants enter the presence, they do not file WS and they do not lead their evidence. The matter was posted to judgment. In 2023, they come, they file recall applications and then they file all these applications, my lords. Presently,
Council has reiterated.
they're old age and poor people, my lords.
Has reiterated the very same amendments. Reiterated the same contentions as stated before the trial court and submits that the plaintiff has to be rejected. Then counsel appearing for the respondent submits that the suit, the court has rightly rejected the application. In fact, considering the age of the parties, there should be a direction to the court to expeditiously dispose of the matter. It is submitted, there are no reasons to interfere with the well-considered order passed by the court. Next para, having other counsels on either side peruse the material on record. The petitioner is relying upon a partition between him and his wife. How the wife can be a member of a joint family and how it amounts to a partition, this court is not able to appreciate the said submission. The trial court has precisely considered the said aspect and dismissed the application. This court do not find any reasons to interfere. The plaintiffs are aged about 68 and 66 and the defendants are aged about 75. The first defendant is aged about 75. The second defendant is aged 58 years. Considering the fact that these are all the three are the senior citizens, the trial court is directed to dispose of the suit as expeditiously as possible, but not later than 1 year.
Cell number
Please,
37.
my lords.
Karthik Surya Prakash.
Paying for R1, R3 and R4, my lords. Undertake to file wakalat for R2 as well. I appear for R1, R3 and R4, my lords. Undertake to file wakalat for R2 as well. It may be had next
And
week.
counsel for the respondent submits that he has instructions to file wakalat on behalf of R2.
R2. It may be had next week, my lords.
Avoid service. Maintainability of CRP is kept open. Interim order is there.
No, my lord, there is no interim order in the present case. My lord, this is an application.
At the request of counsel for the petition, lists this matter on 9th of September. Yes, next.
Cell number 38.
Date, my lords. Date, my lords.
Yes, next.
Cell number 38. Ravindra BS for petitioner.
No representation, list in the month of October for the petitioner. Yes, 38.
Cell number 38 only.
39.
39 Manjunath HR.
Part 7, Rule 11 AD application came to be rejected. In MC
Then what, why the office has raised objection with
It
regard
is in
to
the MC proceedings, filed an application, please.
family court?
Family
Then
court.
it has to go before the court.
No, my lord, it is very much maintainable before CR.
Oh, any proceedings arising out of the family court,
Yes.
it will go before the family court, before the court having roster, family court matter.
Because a CRP, it will come before.
The office objection with regard to maintainability is maintainability is sustained. The petition, this matter shall go before the court having roster of family court. Yes, next.
Cell number 40.
The
Chetan
trial
Desai.
for petitioner, your lordship. The honorable trial court
Court
has
is
given.
dismissed.
With a liberty, your lordship. That's why you are challenged. The suit is dismissed, not along with the liberty is granted to subject to the law of limitation. With the liberty is given. So we have filed a revision petition. While giving the liberty, the honorable trial court has not followed order 23 rule 1's clause 3. And the order may be seen at page number 11, your lordship. A simple order has been passed without hearing me.
We'll see. Notice to the respondents and summons. Yes, next 41.
Till number
Good night.
41. Suraj.
Lords, appearing for the petitioners, my lord. Lord, seek for a short accommodation.
Yes,
Lord,
this
senior
is matter
Next week
in the
may be
month of
posted, my
October.
lord.
Yes,
Till
42.
number 42.
Lord, I appear in 42. Lord, may I request that this matter be taken up next week, Lord?
What are the two IAs?
Lord, one is seeking to challenge an order refusing to grant me amendment of my plaint, Lord. The other is an application for classifying this suit as a representative suit.
The petitioner shall file office objection with regard to filing two IAs in one writ petition is sustained. Petitioner shall come up with two applications. Yes. Yes,
Number
next.
43.
Shall file two writ petitions.
No, Lord,
Yes.
I'm not pressing on that. I'm not pressing on the IA in which we asked for the suit to be classified as a representative suit because the
So
court has
which
said
which IA?
on amend. I'm only challenging IA which relates to the amendment of the plaint. No, that's all. I'm
The
not going to press.
petitioner is only restricting his relief in this writ petition as far as an IA rejecting the amendment.
617 application. Yes. Ma'am.
Yes. Let's
Yes.
this matter next week. Yes, 43.
Till number 43.
Lordship,
Arjun Basa Reddy.
the copies have been served, Your Lordship, as per the order.
On R1 to R13.
Yes, Your Lordship.
A memo is filed stating that as per the order passed by this court, notice is served on counsel appearing for respondent 1 to 13. Yes, notice to so and so is held sufficient. You have an interim order.
Yes, Your Lordship.
Interim order earlier granted is extended. 44.
Number 44. Chandrasekhar C.
What is this counsel
For
submission?
the respondent number 1.
Yes.
Kindly direct the petitioner to survey
Serve the
copy.
copy.
What is this counsel submission?
Lord, there is a discrepancies in the
For
name.
the above
In
office
the
objection, the counsel for the defendant
the
wrongly
IA, they have
mentioned the
not
name
described the.
Lars of however correct name mentioned in the amended plaint and certificate for the amended plaint furnished. The same may be taken on record. Office objection with is overruled. Yes, so the papers on you.
Please.
This is in the month of September. Is 45.
Till number 45. 45. Raghavendra Raj.
What are those two prayers? Let's see. That. Office objection. With regard to the maintainability of the writ petition is overruled. Yes, listed in the month of September. Is 46.
Number 46.
And for petition, my lordship. My lordships, the common order passed on the both IAs. One IA
What
for
are those IAs?
order 1 to 10, order 6 to 17, my lordship.
There are two different IAs.
Yes, my lordships. One implementing for proposed defendants and another IA is
Restrict this to one IA, whichever IA you want.
order is same. One common order, my lordship. Both IA, the trial court passed common order.
No, this court will allow one IA, dismiss other IA. What will happen?
My lordship, some ancestral properties are not pleaded at the time of the filing of the because the.
Where is that order? Page number.
Profile. Page number 10. 10, page number. Page number 10, madam.
Page number 10.
10.
Yes, of council submission with regard to the maintainability is accepted. Yes.
Then number 47,
Petitioner, my lord.
PC.
So I report the death of respondent number 2. The petitioner and respondent number 1 are the only children's, my lord.
When R2 died?
After filing of the petition, she died, my lord.
Mm.
The mother of the petitioner and first respondent mother.
Then you have to take steps.
No, they are already on record. Their legal heirs are already on record.
Who are the legal heirs?
The first petitioner and first respondent, my lord.
It is submitted that a memo is filed stating that R2 mother died on 8/4/2026. Already the LRs are on record, that is the petitioner and the first respondent.
Yes, ma'am.
Accordingly, the memo is taken on record and the petition shall carry out necessary amendment.
Then number 48, L. Srinivas.
Yes, 48.
Petitioners are the plaintiffs in the suit, my lords. The council submission with regard to two aspects, my lords. One, the D2, D3 have been placed ex parte. That is why I have not arrayed them in the writ
You
petition.
have to array them.
No, my lords. The present writ petition is for challenging the order taking the written statement of D1 and D4 on record, my lords, after 5 years, 17 days, my lords, without even condoning the delay. D2, D3 have not been, they have been already placed ex parte, my lords. We kindly see 29/11/2023, the D3 was placed ex parte. D2, my lords, partnership firm also placed ex parte, my lords. Now, my lords, may kindly see the other submission which is made, which is the other three IAs, whether a common writ petition is maintained against the other three IAs, my lords.
For those 3 IAs.
Please, one is permission to file the written statement. The other two is to recall and reopen the stage, my lords. All are filed in.
Objection.
There is an interim prayer, my lords.
Objections. No, it's coming up for orders. You do it, office objection with regard to the office objections raised for order. This is matter for preliminary hearing. Yes, 49.
My lords, the trial court 11/9, my lords, earlier date, my lords. I'm only asking for an earlier date.
No, I just said list it for preliminary hearing. It will come.
Trial court is at 11. The date is 11.
11/9. But I said it will come in 2 days.
Please, great.
Yes, 49.
49, PC.
Lordship, copies has been served in the open court before the trial court itself. Lordship.
My lord, I'm
One
for
respondent.
I'm for
Only one
respondent, my
respondent
lord.
is before this court.
Venkatesh GR.
Please,
You
my
have
lord.
already filed wakalat.
I file wakalat, my lord. I request to file objection to the writ petition, my lord. Kindly in the next week, my lord.
Notice to respondent is served. Wakalat is already filed. Then counsel the respondent seeks time. This is matter in the month of September.
Interim order may kindly extend.
Interim order earlier granted is extended. 50.
50,
Obliged.
number for
I'm restricting only on IA5.
Something like memo of liberty
Memo,
to
I
file
filed a
fresh
memo
petition.
that it is not correct, but memo I clearly mentioned. I am restricting only on.
It is stated that the petitioner is only restricting the prayer to annexure C. And as far as A and B are concerned, he may be permitted to file a separate petition. This is matter for preliminary hearing. Yes, 51.
number 51, Kalyanar. Awaiting for-
For the respondent, I have filed wakalat for 2 to 4 today, Milal. But R4's name is wrongly mentioned. It is not in conformity with the plaint pleadings. Because that is necessary change. It should be Lingaj heirs, but it is different.
The petitioner shall, it is submitted that in the cause list, the array of
R4s.
parties and the names mentioned are not as per the plaint. The petitioner
Not
shall
in
carry out the
conformity with
necessary
the
corrections.
Plaint.
Yes, this is matter in the month of September. Yes, 52.
Number 52,
Office objections already over, my lordship. Office submissions.
No, memo for dispensation. That's what is coming up.
Dispensation is for R7 and to 9. They are placed ex parte.
R7?
To 9.
As memo is filed, same R7 to 9, they have set ex parte before the
Trial
court.
court is fixed date
Yes,
for
yes.
27th. then.
Huh?
27th, my lordship, for different arguments. That's fine.
What is to be done now?
Earlier date to the 27th, my lordship.
This is matter on 27th. Yes, next
First
53.
list, my lordship. Lordship, in the first list of 27.
First list. 53.
number 53,
Your Honor, the senior is unwell. Short accommodation.
No, some memo of compliance file. What is this?
Your Honor, needs seniors interest.
Yes, next week.
Next, after 5th September, after 5th September.
After 5th September.
Need.
Yes, list in the month of September. Yes.
Number 54.
Your Lordship, as per the directions of this honorable court, I have deposited the award amount as well served the hand summons and produced the copies before this honorable court.
Then counsel, the petitioner submits that the interim order passed by this court is already complied with. And notices are also served on the counsel appearing for R1 to R4.
Yes, Your Lord.
Notice to R1 to R4. The same is taken on record and held sufficient.
And
Yes.
this honorable
Interim order
court-
earlier granted is extended.
This honorable court had called for the report from the judicial
there?
accounts.
Report is there. On the last occasion, this court has passed an order directing the registry to place the report. It is not placed, the registry is directed to place the report as per the earlier order dated so and so. List this matter on Monday. Is 55?
55.
My lords, in this matter, I appear for the petitioner, my lords. My lords, I've taken process, my lords. However, with respect to hand summons could not be taken as the miscellaneous pending is disposed matter, my lords. It's not pending consideration to serve it on the
After service of notice.
My lord, interim order may kindly be extended, my lords.
Interim order earlier granted is extended. Yes, only 230 matters, nothing else. I will not be hearing any matter.
My lords, the Honorable Supreme Court has protected.
An admission.
Give it to the court officer. Don't have to mention that. Take that. Yes.
That's
Huh? When? When was it passed?
It was passed last week. Then the CRP is pending before this one.
Yes, list this matter tomorrow. Yes.
It's a
Well,
matter
the
of
Honorable Supreme Court-
CRP. We moved the admission. The matter was listed before the court on 19/8, my lord. The matter was not reached, my lord. My lord, the other side, without information, other side, my lord, he has taken time. It is posted to August, this August, September. My lord.
So when do you want?
My lord, admission has to be posted, my lord. Matter has to be posted.
No, what is urgency?
My lord, urgency, my lord, the proceeding is the matter and moving the interim order, CRP matter. But the suit has, previous suit has already been dismissed. And once again, they filed another suit for bare injunction and moving the matter for injunction.
I don't understand what is urgency.
My lord, urgency is that, my lord, they are threatening the,
If they move, court has to pass an order. If court passes an order, you have a remedy to come to this
true, my
court.
lord, true, my lord.
That cannot be a ground.
No, my lord, no, my
Anyhow,
lord.
that is already
The
adjourned,
apprehension,
adjourned. Yes.
My lords, the
apprehension is
Honorable
that, my
Supreme
lord.
Court, my lord, has protected my possession, my lord, till 30th of September. Yeah, overreaching that, my lord, the trial court would pass a delivery warrant. And today, my lord, they are already, my lord, taking over the possession. It's a huge theatre, my lord. Around 150 people, my lord, have barged into the theatre and they are dismantling, my lord,
When was the order
equipments, my lord.
passed by the court?
On Thursday, my lord, the 20th. Friday was a holiday, my lord. Today, they are already, my lord, executing the warrant, my lord.
2:30.
2:30.
Extension of interim order.
2:30. Then in that case, we will dismiss it. You please come back in the afternoon. When I take up that matter, we'll dismiss it. If that's the case.
Application, my lord, extension of interim order.
One matter for
For a
extent.
week, all of you.
At the end
My
of
lords,
the-
my lords, pertaining to the sale alienation which took place before
Give
2004.
all the memos to the court officer.
My lords, slight urgency in this matter, my lords, they are acting upon.
Court officer.
ನಾಳೆ ಕೊಡಿ.
Rush matters ಇಲ್ಲಿ ಕೊಟ್ರು ಹೋಗು ಕಳ್ಸಲ್ಲ ನಾವು. Only pending matters.
ಆ ಕಡೆಯಿಂದ ಬರ್ಬೇಕು.
Hello.
Many passwords are there. Call.
Passover matters. Serial number 12. Passover serial number 12.
For the petitioner.
Yes.
Your Lordship,
Where is the impugned order? Where is the impugned order?
11 to 25, page number.
Hmm?
Page number 11. 11 to 25. Shoot for partitions.
What happened to this application?
Rejected.
Who are you?
I am the son of one Peddanna.
Hmm.
Peddanna is the Karta of the family. Plaintiff, debate number 1, 4 to 9, and impleading applicants are the legal heirs of the Peddanna.
Hmm.
Peddanna had 5 issues, namely Tippamma, Naran Reddy, Balappa Reddy, Lakshmamma and Gauramma. I am the son and daughter of Lakshmamma and Gauramma.
Come to the order. Read it from page number 17.
My lordship. Last bottom.
Last para.
Yes, ma'am. As the present suit is filed among the family members of Naran Reddy, the presence of us is not required for adjudication of the subject matter of the present suit. They admit said Naran Reddy and we are the.
Yes, what do you say?
Previous round of pleading application filed by Balappa Reddy, and this honorable court, the trial court dismissed that application for impleading, and thereafter there was another WP filed by Balappa Reddy, which again came to be dismissed, stating that.
So what is the relationship in Balappa Reddy and this petitioner?
Sister's son-in-law. Sister's son.
Where is that order?
Orders are produced before the honorable court in WP 2978 of 2017.
Hmm.
I will draw a lot of submissions. At page 5, the petitioner application is filed under Order 1 Rule 10 and is rejected by the impugned order dated 27/6/2017. The suit is amongst the family members of the deceased, Sri Narayanappa. The petitioner, Balappa Reddy, is no more and his legal representatives have come on record. There is no dispute that the deceased Balappa Reddy and Sri Narayanappa are brothers and they are parties to different earlier proceedings, including the suit so-and-so, which has culminated in the court's judgment dated so-and-so. In RFA number, Sri Balappa Reddy has filed a petition in RP 39 of 2015 for review of the judgment dated 3/9/2004, and this review petition stands disposed of with the observation as your honor. This is important. What is the plain? I will just draw your options to the last 5 lines, which is underlined. The rights or succession of plaintiff, defendant, and other sister is a matter that has to be thoroughly gone into in a properly constituted proceedings. It is submitted that the sister has filed a suit in OS number 1168 of 2004, seeking a share in respect
Yes,
of.
how are you entitled for any same order also applies to you?
I am the daughter and son of Peddanna. No partition held in the family. Naran Reddy solely alienated the certain property. He, my learned counsel said that is different properties. Different property filed by not the Balappa Reddy.
The same property was sold alienated by the same Narayan
Please
Reddy.
come.
Same Narayan Reddy.
The
respondent is the purchaser.
The agreed with order passed number 9 invoice number 1469 of 2014 by the 29th edition citizen and session judge at Bangalore dated 4 December 2025. The petitioner implead applicant is before this court. He has filed an application contending that he is a necessary party to the suit and it should be completed. That came to be rejected by order impugned. Wherein the court had taken into consideration the earlier order pertaining to Balapareddy, one Balapareddy, who has filed an application under Order 1 Rule 10 CPC. The said Balapareddy is none other than the brother of Srimati Tippamma and Srimati Gauramma.
Reddy also is
And the petitioners are the family members of Srimati Tippamma and Srimati Gauramma. When an IA is filed in the present suit under Order 1 Rule 10, that came to be dismissed by order dated 27/6/2017, agreed thereby, the petitioner agreed thereby the said Balapareddy has filed a writ petition before this court, that is WP number 29778 of 2017, which came to be dismissed by order dated 9th August 2023.
And that's it. Balapareddy not filed partition.
I didn't say Balapareddy filed OS. I said Balapareddy filed IA.
Balapareddy and Narayan are brothers.
Yes, by order dated 9th August 2023. While dismissing the application, the court has observed that though Balapareddy has relied upon the last will and testament executed in his favor by his father-in-law Peddana on 11/7/1974, the merits of Sri Balapareddy's right based on the last will and testament or otherwise will have to be considered only in the appeal filed by him against the judgment dated 25/10/2019. The question whether Sri Balapareddy could have any interest in the suit scheduled property either because of the aforesaid last will and testament or because of devolution of interest mentioned by the court in the order dated 13/10/2006 must be considered in the proceedings amongst the primary family members. If there is any decision or any settlement inter se, the next family members in a separate suit, such decision or even a settlement will have to yield to the decision in the proceedings amongst the primary members. Therefore, the court is not persuaded to interfere with the civil court's impugned order, and the petition stand disposed of, observing that all questions as regards the petitioner's interest in the suit scheduled property must be decided in the appeal as against the judgment dated 25/10/2019 in OS number 1168 of 2004. The court, considering the said judgment, said order passed in the writ petition, has dismissed this application. That stating that in view of the orders passed in WP number 2977 of 2007, the applicants have to agitate their right in the appeal which is filed against OS number 1168 of 2004. As the present suit is filed with the family members of Narayanappa, the presence of the applicant is not necessary, and accordingly dismiss the application. Land counsel appearing for the petitioner submits that when they are claiming right in the properties, suit scheduled properties, they are proper and necessary parties, and this aspect was not considered by the court. And basing on an order passed in WP number 297778 of 2007, as dismissed the application, the court ought to have dealt with this application independently. Next parallel, and counsel appearing for the respondent submits that with regard to the dispute between the parties in the suit, The, the implead applicant has nothing to do. As in case of Balapareddy, earlier writ petition, that is 29778 of 2007, has been disposed of to agitate their rights in OS number 1168 of 2004 that applies rightly to the petitioner, and the court had rightly dismissed the application. Next, for having heard the counsels on either side, there is a material on record. This suit is filed Narayanappa is filed. Who filed it? The suit is the legal heads of Narayanappa has filed the present suit. Swan Sri Peddana was the propositor of the plaintiff's family. He had 5 children: Tippamma, Narayanappa, Balapareddy, Lakshmamma, and Gauramma. In this suit, when one of the son Narayanappa, one of the son Balapareddy wanted to implead himself, that request itself is rejected by the court, which is affirmed by the coordinate bench of this court in WP number 29778 of 2017. The petitioner, who is he is related to
Brother one, Narayanappa. Narayanappa.
Tippamma and Gauramma.
The petitioner is related to Tippamma and Gauramma, who is none other than the sister of Narayanappa. When the claim of Narayanappa itself is rejected, the same applies to the case of the petitioner also, and the court had rightly rejected the application, and this court finds no reasons to interfere. Dismissed.
Cell number 20. Cell number 20, Rajesh. GS for petitioner. 20 and 21 same.
None appears. Does this matter in the month of September? Yes.
Cell number 21, same at 30.
Yes. Next.
Cell number 20. Cell number 27.
Yes. What do you call?
Cell number 27.
Yes. Ah. 28. 553. Yes. Yes.
And the owner of not 1 acre of land not undisturbed. What has happened is there was not a suit filed by me. Please come to not running page in the same paragraph 7, page 34. I had earlier filed a suit. OS number 1, 2, 3, 4, 5, 6, 7 line on the top. OS number 219 of 2014 on the file of the senior civil judge Bangalore against defendants 1 and 2. Who subsequently sold it in February 3rd defendant, and he has the right to interfere, and we have filed this suit. He look at it, this was decreed. So there was an injunction against them, restraining me from interfering in my possession. Then after if my lord sees cause of action at page 11, page 36.
Yes.
Cause of action for the suit arose on 25/4/2014 and subsequently on 2/9/2020 when the defendants are illegally alienated. What happened was there was an injunction against them. They alienated by a means of an illicit sale dated 2/9/2020. That's when based on that, defendant number 3 trespass next night. Alienated the suit on to the third defendant pending litigation on 24/7/2021 and 4/8/2021 when the defendant state illegally interfered in the suit position. Suit property was subsequently used. So, I filed a suit. If you look at the prayer and page 36 at the bottom, decree that declaration that I am the owner of the property. That there was an injunction in my is not undisputed. Therefore, permanent injunction against them. So, actually, is redundant. At any rate, my lord, it does not matter. Then, my lord, B, they have not denied my title. B, decree and declaration declaring that the register seal being dated 22/9/2020. My lord, is executed in favor of so and so is not binding on me. Then, my lord, restrain them from interfering with my possession. My submission to your lordship is cause of action arose when, my lord, they sold the property, and, my lord, illegally, and, my lord, when, my lord, the third defendant tried to interfere with my possession. Therefore, my lord, suit is within time is my submission to favor. Their argument is suit is part of illegal. They have given to your lordship, my lord, 4 judgments. If my lords just look at, my lord, those judgments, 2 of them, my lord, which have some value. My lord, one loose judgment was given. My lord, latest judgment according to them, my lord, of Justice Pardiwal. Can I request your lord to get, my lord, paragraph 4 therein?
Yes.
If my lords come to, my lord, line number 4, there was a joint venture, my lord, agreement entered into between the parties. Line number 4 at paragraph 4. Joint venture was also related to construction of apartment in 2 plots, which construction was obligation. That having been complete within time, 15 months as specified in the agreement. Joint venture was cancelled by issuing a written notice on 2/4/2006, followed up with a lawyer's notice. Respondent filed, my lord, replied on so and so, disputing the whole thing. Ultimately, my lord, the suit, paragraph 5, is filed in 2020. Obviously, my lord, after, therefore, my lord, it is barred by limitation on the face of it. Please look at, my lord, the compilation that they are given to us.
Yes.
First one is, my lord, limitation starts when, my lord, the cause of action, my lord, accrues, and I had full knowledge. My submission to your lordship is, I, my lord, did not have, my lord, the knowledge, my lord, I became aware of it, steady it is, my lord, in the year 2020. I filed the suit, my lord, within 3-year period. Therefore, my lord, it is within time. They tried to interfere in 2021, it is within time, 3 years. Therefore, my lord, the first judgment has no application. If my lords come to, my lord, paragraph on serial number 4 and 5, sorry, 5 and 6, please come to, my lord, page 66.
Page?
66. That is what they are trying to, my lord, rely upon. Paragraph 13 to, my lord, 19 is what they are saying.
I think Uma Devi was not referred to by them, though it is placed. What was
Devi-
referred to is 6, serial number 6.
6, no?
Serial number 6, serial number 3, they have referred to.
Serial number 3, can I request you to look at serial number 3? Serial number 3 is a general proposition. You don't want to say anything. In fact, it arose from our High Court. If my lords have seen the judgment, where, my lord, Justice Venkatraman says, I have spent sleepless nights. One, my lord, buyer, he, my lord, directed the judge, Justice Venkatraman. What can he say? Don't take up the matter. Then, my lord, he, and let it go to somebody else. He, my lord, in fact, he said, I spent sleepless nights. And that was a case where father had filed a suit. That was dismissed. There are my lord, son files. Therefore, my lord, obviously, my lord, the same property, father and son are residing together in the same property. Therefore, my lord, that 3 has no application. Then let us come to 6 more. If your lords come to, my lord, serial number 6, ultimately, my lord, what is all that they are relying upon, page, last page, my lord, not 4.
Yes.
At this juncture, we wish to observe, we are not unmindful of the law of limitation, is a mixed question of fact and law. And the questioning of rejection of claim on the suit has to be decided after weighing evidence and record. However, in case like this, where it is varying from the claim government, then the suit is hopelessly barred by limitation. Court should not hesitate to grant. Therefore, my lord, if it is hopelessly barred, definitely not I will not. I give you a lordship not poor judgment for my lord's consideration.
Yes.
Have a look at. Well, the first judgment is, my lord, general proposition. That, my lord, please look at, my lord, because this has some relevance.
Para number?
19. I put, my lord, in the beginning itself, I put a short note.
Yes, I've seen.
I know that. It's
Yes.
not that easy.
Yes.
You may not argue, put everything on your lordship. You look at paragraph 19. It can't be done, my lord, in abstract. That's what, my lord, the Honorable Supreme Court has said.
Yes.
Specifically.
Yes.
A plea of limitation, 15. A plea of limitation cannot be decided in abstract principle of law. Divorce from the facts as in every case, starting point of limitation has to ascertain, which is entirely a question of fact. A plea of limitation is a mixed question of law and fact. Question whether the words part by law occurring in order 7 to 11B CPC would also include the ground that it is part by
I
law.
think yesterday latest judgment reported they've taken a different view, apex court with regard to limitation.
No difficulty about it. I am not saying, Lord.
Yesterday's judgment, I think.
No
That's
difficulty.
the same one which I passed.
This is the one, Lord, there. There, Lord, it's hopelessly part on the Lord's of 2016, they cancelled. 2022, Lord, after Lord 5 years, they have filed. Naturally, Lord. In this case, sale deed, Lord, is in the year 2020. 2014, Lord, I got a decree. That decree, Lord, has nothing to do with this. Merely because, Lord, I get a. In fact,
So whether it is a question of limitation is a question of fact and law necessarily depends upon the facts of each case. In each case, it need not be a question of fact at all. Yes, yes,
Then, Lord, please look at the third judgment, fourth judgment.
yes,
I'm very satisfied.
yes.
Fifth judgment.
Fifth judgment.
Fifth judgment. Lord, other elements are all, Lord, saying that one has to look at, Lord, the factual matters. My submission to you, Lord, is we have to look at the factual matters. 2014, my suit came to be decreed. 2020, they sell the property. That's when, Lord, cause of action arises. 2022, 21, Lord, when they trespass, cause of action arises. Therefore, Lord, I am within time, within 3 years. 2014, my suit is of no consequence. It was, Lord, I don't know why they have put it. Even if, Lord, it is of no consequence, this is not a cause of action actually. Cause of action is, Lord, 2020 and 21. Please look at, Lord, the judgment at page 73. Please come to paragraph 35.
Yes,
A partial, Lord, rejection of a claim is not permissible.
yes.
Paragraph 35. The Lord's got that one at page 91.
Yes.
First question to be answered. Do these disputes involve any question, whether legal or factual, on which the existence or extent of legal right of the plaintiff depends? If it does, then the next question is whether the raising of such dispute is part by law. If any of these questions is answered in the affirmative, claim cannot be rejected as a whole. On the other hand, if any part of the dispute has to process both parties, suit must arise because there can't be a partial. In this case, Lord, 2014 is my suit decree, no consequence. 2020 sale deed. That Lord, I am saying that Lord, I am the owner of the property. Therefore, Lord, sale Lord does not bind me. Within time of 3 years, 2021, they will not try to Lord interfere. 2022, I filed this. Therefore, Lord, within time. That's the reason why. Even if Lord 2014 is taken into account, my other two payers will not survive. If that is so, Lord, partial rejection is not permissible. Is what on.
What is, let's come to the prayer.
Yes, Lord, before that, can I see? Just one
Yes,
more
yes,
for my Lord's consideration.
yes.
Please get Lord, please 130. I'll come back to the Lord, this thing itself. Please come to Lord, paragraph 23.
110,
Same
yes.
thing, Lord, is reiterated that Lord, there can't be a partial rejection of the claim. Now let us look at what the claim is. This Lord is paragraph 23, Lord, my Lord said that, and running page, Lord, the 131. 131, para 24 is more.
No, you're relying on judgment? Huh. 130?
131. There are a couple of issues. One issue will not is part by limiting the other not. Then will not, one can't will not say I will dismiss the reject the claim. That's all. Now we are coming back to this is proposition which is there, paragraph 24, page 131. Now come back to Lord, if I can come back to your Lordship, Lord. Page 36, Lord. Declare that I am the owner of the property. This arose because they, my Lord, sold the property in 2020. I filed the suit, my Lord, in 2021. Therefore, my Lord, it is within time. Second, decree declaration that, my Lord, registered sale deed of 29/2020, my Lord, is not binding on I'm the owner of the property.
No,
my
this
lord,
is,
he sells it.
is it a consequential to this or it is an independent prayer?
It's not virtually an independent prayer. Virtually an independent prayer. But even if my lord, declaration my lord is not given, this my lord survives because say on the face of it my lord is untenable.
Yes.
Third, injunction my lord to restrain my lord the defendants from interfering by peaceful possession. That is because para 11 my lord, yes, above that my lord, if you not see. The interference occurred on 24/7/2021 and 4/8/2021. I set down that at paragraph 9, where my lord, they came in, tried to trespass, I my lord resisted, and they ran away. And they said they'll come back. Therefore, my lord, I have to dismiss. Therefore, my lord, by sufficient your lord says that my lord, even assuming that my lord, the declaration my lord that I have sought for in A, it's not barred by limitation because my lord, the cause of action arises when my lord, they sell my property in 2020. Assuming for the sake of argument, my lord, that it is, other two my lord also survive. Other two my lord will always survive. Therefore, my lord, looking at any angle, my lord, my submission is that.
Yes, Mr. Sinekal.
That's what the trial court has also.
Yes.
Firstly, my lord, sir.
No, on this, about a partial rejection of the plaint.
My lord's partial rejection, it's a settled position. I will not even argue that a partial rejection. But please see the prayer. My learned friend's senior's assertion that prayer B in the plaint, my lords, that's at page 36, can independently survive and not be correct. For there is unless the plaintiff is the owner, my lords, the question of him seeking the declaration that somebody the sale deed in respect of a scheduled property is binding on him may not arise. If A goes, prayer A goes, my lords, prayer B will not even survive. It is not a partial rejection at all. My lords, my learned senior was saying that the suit of injunction was decreed in 2014. Not that the suit was, yes, no, again, Tondre illa, sir. My lords, that's, he will not, it is only a small mistake. I don't even say, lords, the suit was decreed in 21, but it was only an injunction suit. But the
No,
plaint,
in one case it is decreed in 21, in other case it is dismissed for non-prosecution.
that suit, my lords, we do not know which
Because
number.
numbers
also.
are not given in that.
It is not given. But that's only an injunction suit. But what is missed out is in the plaint, my lords, if the lordship see the plaint, they speak about, they are try to assert their right in 2014, 13-14, when the mutation was carried out in, my lords, one is Krishnamurthy, my lords, I'm sorry, I am only the purchaser, but my vendor, when the name came in their name, they tried to assert their title by filing a revision, my lords, challenging the mutation entries. At that point of time, they became aware that, my lords, there was a sale or a title in respect of my vendor. D3's vendor who is D2 and D1. That's, at that point of time, they should have instituted a suit. Now, my lords, my vendors got their mutation done. In the written statement, my lords, there is a categorical, anyway, written statement cannot be seen at the stage of 711, but there is a denial. 2014 is when they came to know that somebody else is asserting title, they should have filed a suit. Or they could have amended their injunction suit seeking declaration of title, both of which they do not do. Now, 2020, when the vendor sells it to somebody else, that is not when the cause of action arises. Cause of action is 2014. Lords, and the judgments which we referred only say, my lord, that the first cause of action should be seen. That, my lords, in fact, the learned senior referred to everything. But, my lords, only one para I want to show in the compilation which we had produced before, my lords.
Yes. Yes.
When the first cause of action
Arose.
Lords, that is yes. The first judgment, which starts at page 1, 2025 SEC online, that's Nikhila Deva. In that, only one para I want to show, para 10. I mean, sorry, para 20, which is at running page 4, which says, my lord, the use of the words when the right to sue first accrues. As mentioned in Article 58 is very relevant and is important. It categorically provides that the limitation of 3 years has to be counted from the date when the right to sue first accrues.
Yes.
And in our case, there is, lords, of course, Umadevi, none of us read it, but Umadevi is, even in a partition suit, Umadevi has held, my lords, that a registered sale deed is a notice to the public at large.
Which paragraph in that?
Lords, I will just, lords, that is the
Relevant para, I think it is written
we
like
have
13,
read-
14,
we-
15, 16, 17 and 19.
19. We have given the para. That's the only. Partial rejection, I accept, my lords, there can't be a partial.
Can I see happened in the, he's come to para 7 of the thing, let it take 30.
7 of the plaintiff.
Then you have to file.
Yes.
The immediate, that was not a CB, they did not have a CB. They got an RTC, but title to does not get on the basis of RTC. But then we challenged it, not just pending before your RTC, permitting the para 7.
Yes.
Plaintiffs are pursuant to the order passed by the Deputy Commissioner, Division Petition number so and so, filed by the plaintiff was dismissed, for which the plaintiff has filed the writ petition WP number 24,001 of 2014, which is pending consideration before this one. Therefore, my lord, the declaration is, when my lord, they sold the property. RTC, my lord, is a separate issue, my lord. I can't, my lord, challenge that RTC before your lordship because under the Revenue Act, there's a bar for civil suit. So, my lord, RTC is a separate issue. Only when, my lord, they sold the property, that, my lord, I get the call.
Yes. Heard.
My apologies, I was not there.
Not.
But
Reserved.
my vendor got this property in 1948 under a sale deed. So, my lords, that is how we have said so. Anyway, my lord, that I can't take your lordships to those facts.
Open the doors. Open the doors. Suffocating. Yes. Any other passwords?
No.
230 March.
That's okay.
230.
Not yet come.
Cell number 56, continuation. Cell number 56.
My lords, in this matter, the stay was granted on 4/8, and we were asked to issue notice to the respondents as well as take out hand summons. On 10/8, we have issued notice to the respondent, but due to inadvertence, there was delay in taking out the hand summons. So filing an IA to extend the interim order as well as.
We will not extend because I said if you don't file it or the interim order automatically stands.
Will kindly permit us to take out fresh hand summons. We'll comply with it tomorrow itself.
Order. That precisely that is why I in every case I pass that order. You happily take an interim order and notice
No,
will
Your Honor.
never be served.
We have issued the notice on 10/8, Your Honor. It was a genuine mistake.
File a memo to that effect by 19/8/2026 or else the stay granted by this court shall stand vacated. It's already vacated.
Kindly, Your Honor.
19th itself.
Will kindly permit us to take out fresh hand summons and
Take out. I will not extend the interim order.
kindly, Your Honor, because we already issued notice. It was a genuine mistake. I acknowledge it, Your Lordship.
If the memo interim order is extended till 1st of September, if by 1st September, if the memo is not filed, evidencing service of hand summons on the respondents, the writ petition shall be dismissed on that ground.
Great.
Yes.
Cell number 57.
I
There is
appear
a-
for the petitioner, my lords.
Yes.
My lords, report was called from the registry, my lords, on the last date of hearing. This is a writ for mandamus, writ of mandamus, my lords. I've sought for speedy disposal of the application, my lords, and the suit, my lords.
The writ petition is filed seeking the following prayer. Considering the fact that it's a suit of 2014, this court has called for a report from the concerned court, how much time it requires for disposing of the matter. The learned judge has sought for 1 year time. Accordingly, the writ petition is disposed of, requesting so and so to dispose of the suit itself within a period of one year from the date of receipt of the copy of the order.
Cell number
Grateful, my
58.
lords.
H. Devendrappa.
Lordship's permission, Lord. Lord, what is challenged here, Lord, is an order passed.
Maintainability is question.
Correct, Lord. It is an order passed on IA number 2, Lord. It is an interim order. Therefore, my Lord, it would be maintainable.
What is that order?
Lord, that order issues delivery warrant, Lord. In an execution, Lord, I am the judgment debtor, Lord. Now, the plaintiff's case is there is a partition deed, Lord, in which he has.
So once a property is delivered, what remains?
I'm sorry.
Once a property is delivered,
No, the property is larger extent. It has 9 acres in Dod, my Lord. And what is the decree is for 1 acre 13 guntas. In the execution petition at page 44, if your Lordship sees. at page 46.
The office objection with regard to the maintainability is kept open. Yes.
Now the decree is for 1 acre 13 guntas. Now in the execution petition, my lord, he says, please deliver 1 acre 30 guntas. If your lordship will see at page 46. My lord, the no, my lord, schedule is given. If your lordship sees 46, page 46, schedule is simply says 1 acre 30 guntas of dry land in survey number 60 of so and so village. No boundaries, my lord. And my lord, during the pendency of the second appeal before this honorable court, my lord, a commissioner was appointed, my lord. If your lordship will kindly see, Lord, at page 57, Lord.
This is the execution of 2023.
Yes, my lord. Please see page 57, my lord. This is during the pendency of the second appeal, my lord, before this honorable court.
There is no stay.
At the moment, there is no stay, my lord.
What is your objection before the?
Lord, I am just pointing that out.
Where
Your
is
lordship
that?
will kindly permit me, my lord. At
Where
page 57, this honorable court's order. Unfortunately, this did not, my lord, come in the final order.
50?
57, my lord.
Fifty-seven.
57.
57 is the order sheet.
That's this honorable court, my lord. In the second appeal.
No.
Annexure E, my lord.
In RSA.
In RSA.
That starts at page 16. And the last is at.
No, that's the final judgment.
Hmm.
Lord, that's the final judgment.
Hmm.
Lord, after the impugned order, my lord, if your lordship will see. Copy. Lord, may I just hand over one copy, my lord, if your lordship?
Yes.
If your lordship permit me, I have one more copy.
Yes.
Lord, the second paragraph, Lord, or the last paragraph on that page, my lord. Suit is filed in respect of survey number 16.
That is at page 63.
63.
Yes.
Measuring 1 acre and 13 guntas in so and so village. The total extent of the land in survey number so and so measures 15 acres, 17 guntas. Parties to the proceedings admit that partition has taken place in the family in terms of registered sale deed dated 18/12/1971. This partition deed is not in dispute. From the records, it is apparent that when partition took place, properties were not divided by taking the assistance of the surveyor, and there was no measurement when the properties were divided. Admittedly, there was no sketch appended to the partition deed which would reflect the exact extent of the property, length and the breadth of the property allotted to each sharer. It is also forthcoming from the records that earlier suit was filed by the very plaintiff and the same was dismissed. And appeal is also dismissed, and thereafter one more suit by the same plaintiff for relief of injunction was also dismissed. In the third round of litigation, however, in OS number so and so was filed seeking possession. However, the trial court dismissed the suit on the ground that suit is hit by principles of res judicata and ground of limitation. First appellate court on appeal being filed by the plaintiff has allowed the appeal and decreed the suit. Hence, defendant in the second appeal. The respondent has filed application to appoint a surveyor and to measure the property. It is forthcoming from the records that the properties were not divided with the assistance of the surveyor when the partition took place in 1971. This court is of the view that survey report would be of some assistance in deciding the controversy between the parties. Thereafter, my lord, the ADLR was appointed, my lord. Now he has, please see, my lord, there is a sketch behind that report, my lord.
Yes.
And my lord, there is a table, my lord, tabular form on the next page. My lord, though it is in Kannada, my lord, 1 acre 13 guntas of dry land is identified in block 4 and 8, my lord. Now, please come back to, my lord, the sketch. Lord, block 4, 8 and 12 are here, my lord.
No, after the survey's report was placed before the court, what happened?
Lord, unfortunately, this did not form part of the decree, my lord. My RSA was dismissed, my lord. Now, my lord, that is why I am pointing out, my lord, the.
It was not taken on record.
Huh?
This is not taken
No,
on.
it is taken on record. It is taken on record. But that is why I am pointing out, my lord, that in the execution petition also, they are silent about the schedule, my lord. They don't give any boundaries. And from 1 acre 13 guntas, it becomes 1 acre 30 guntas. And now, my lord, the impugned order directs, my lord, granting of 1 acre 30 guntas.
The petition is before this court agreed with the orders passed on I number 2 in execution 59 of 2023, then dated 27/11. What is this date? 27/4.
Yes.
Correct?
Yes, my lord.
27/4/2026. Then senior counsel representing the land counsel, the petitioner submits that the court has issued the warrant, the delivery warrant of possession. The suit scheduled property is a larger extent. Now the execution is in respect of 1 acre 30 guntas. And even in the proceedings before in the RSA, the court has recorded that there are no boundaries to the property. And in fact, surveyor was appointed and surveyor has placed a sketch before the court. It is submitted that now without any boundaries, without mentioning anything, the court had issued the delivery warrant. Considering the submission of the land senior counsel, there shall be stay of all further proceedings pursuant to the order date received.
Sir, number
Notice and summons.
59.
Your lordship saying handsome.
Yes. Barretti Kane for petitioners, P.N. Varadaraja
For respond.
Serial number 59, I appear for respondent number 4, my lord. I file undertaking wakalat, my lord.
Appearing for the petitioner. On the previous occasion, your ladyship had passed an order stating that.
There is order sheet 59.
Your ladyship had directed that R4 is not supposed to hand over the DD bearing numbers.
Who appears for R3 and R4?
Your lordship, notice was issued, but the service is awaited, your lordship.
No, I have asked you to take out hand summons.
We have done it. We have filed a memo to that effect as well.
I appear for R4, my lord.
What about R3? Land counsel, so she has instructions to file wakalat.
R3 and R1 are one and same, Your Honor.
You appear?
I'm for R2.
I'm appearing for respond number 1.
R1 and R3 are one and same.
R3 is the director of the respond number.
The so and so has instructions to file
Madam, you
wakalat.
show your name. The post your name, ma'am.
Half of R4. And seeks time. This matter on 10th of September. Interim order
may be kindly.
earlier granted is extended.
Short date.
Show your name, ma'am.
BC Avinash.
Yes.
60. Manjunath.
This
I
is
appear.
to print the name.
I appear for the petition. Maintainability with regard to, there are 2 application order has been challenged in the same suit. Therefore,
What is that? What are those IAs?
IA 151 to permission to file a written statement. Once it is rejected, there on the basis of 120 days amendment. Later, there is a stay by this honorable court. Later, one more application under section 151 is filed by the defendant. That came to be rejected. Therefore, I have challenged both the application orders, earlier order and the second order.
How can it be?
Because there is a stay of the earlier, my lord, the suit has been filed for partition. The defendant entered appearance on December.
Where are those 2 orders? Please show to the court.
Please, my lord, 2 orders.
Where are the 2 orders?
My lord, the earlier IA number 8 was filed to file a permission to file a written statement. That came to be dismissed on the ground that 120 days is a mandatory for a even partition suit as per the amendment of the CPC, state amendment. Later, there was a stay by this honorable court.
What happened to that suit, to that writ petition?
Writ petition, now it came to be disposed of, saying that the 120 days fixed under the amendment is not mandatory as that of a commercial
Think
suit.
about where is your writ petition?
I have not filed any writ petition.
You're
This honorable
referring
court
to.
has stayed the.
That you forget
Yes.
about what
Yes,
this
my lord.
court did.
Yes.
So where are these two orders?
I have filed. At page number, earlier order at page number 41, ma'am. IA number 8.
Yes.
Later, my lord, I immediately on the next date, I filed an application saying that the reliance made by the amendment.
Can you do it?
Sorry.
Can you do it? Already the court has rejected. Without questioning that order, where is the question of filing another application under 151?
No, my lord. By mistake, my lord.
The petitioner.
Sorry, my lord.
Office objection with regard to the maintainability is appealed. The petitioner.
Now I have paid the court fee,
petitioner, not court fees. The petitioner shall file two writ petitions. Yes, next.
My lord,
Bill number 61.
Yes, next.
My lord, I may be permitted to withdraw and I'll file two writ
Yes, the
petitions
petition is
separate.
permitted to withdraw this writ petition with a liberty to question the two IAs by filing two independent writ petitions.
Please, great.
61. Varun J. Kumar
For the
Patil.
petitioner. The office objection for which I have written a submission is annexure. See, the first page is missing since it's a 2004 matter. The original records also, the first page is not there, your lordships. The order sheet, which bears the cost title, etc., that is not there in the trial court also.
You are questioning 2004 order now. You are questioning 2004 order now.
No, your lordships, I am only seeking mandamus saying that FDP proceedings be disposed of. It's of the year 2004, your lordships. It's still pending. Suit is of the year 92.
The registry is directed to call for a report from the concerned court. How much time it requires to dispose of the matter? Office objection. Office objections is overruled.
Please.
Yes.
Bill number.
A council submission is accepted.
Please.
Yes. I've already adjourned that matter, I think. Yes, code officer. That matter is adjourned. No, that I've already adjourned. Yes.
Bill number 62. Nagendra M for petitioner. KG Sadashivaya.
Respondent.
We
I have
have
not been
engaged
served
the
with the
senior
copies.
counsel in this case, my lord. We have engaged the senior counsel in this case.
I have not
He
been
is head
served
up
with
in
the
another
copies,
court.
my lord. That
So
will
the
be-
papers on him. Yes. This is matter
Seats,
on
short.
24th of September.
Bill number
Yes, 63.
63. AV Gangadharappa for petitioner.
The reference court has dismissed the petition on the ground of limitation. However,
For you, you're seeking permission to
I
prefer
am the beneficiary of the acquisition.
the IA number 2 of 26 is filed seeking permission to prefer the CRP. It is submitted that the land is acquired. The petition is the beneficiary. IA number 2 of 26 is allowed. Notice on IA number 1 and 3.
Please.
1, 3 and 4.
Bill
Yes,
number
64.
64.
Notice.
Bill number 65.
Yes, 65.
About the respondent first.
Manjunath Prasad.
I filed this application seeking permission of this court to get the license renewed for this reason. For this reason, at the time of admission of the petition, this honorable court passed an order not to precipitate further. Therefore, my lord, for the year 25-26 and 26-27, I could not able to get the license renewed. Now, only I am seeking a permission from this honorable court to get the license renewed in my name, subject to, my lord, my peril. Subject to my peril. Tomorrow, if this honorable court holds in favor of the petition, then she will get the license. That partnership firm will get the license. If suppose writ petition is dismissed, I'll get the benefit. Now, my lords, the license is now.
No, in his writ petition, why will the court pass an order in your?
Because the license was transferred in my name.
No, whatever it is, in his writ petition, why are you entitled for a relief?
That's what happens. I'll just explain. What happened was, my lord, the partnership firm had the license. Ultimately, my lord.
What is the interim order in this?
Not to, before filing a writ petition, my lord, the license was issued in my name. By cancelling the license in the name of the firm, it was transferred to my name, say, holding that there was no proper transfer of the license in favor of the petition. That order was challenged in the Karnataka Appellate Tribunal. Karnataka Appellate Tribunal dismissed the appeal filed by the appellant here. Then, by that time, my lord, the order passed by the commissioner was executed and the license was transferred in my favor by the deputy commissioner of excise. During the pendency of writ petition, this honorable court submitted, because by that time, my lord, though the license was transferred, there was an interim order by the commissioner not to operate. So I was not operating. Therefore, this honorable court said, till the disposal of the writ petition, don't precipitate further. That means I should not operate. But what happened is, my lord, the license expired on 30th of June.
No, pleadings are complete.
Pleadings are complete.
Yes, this matter on 2nd of September, finally,
Cell number
for
63.
representation on behalf of the
Plus,
petitioner.
any earlier date.
2nd of September,
I know my lord's board is very heavy, but
yes,
Cell number
my lord,
66.
it may be posted for final hearing.
yes. Yes,
Haji
yes.
George for petitioner. Cell
Appeal
number
for petitioner,
66.
madam. Press time for short
Done.
accommodation. Press time for short accommodation, madam. Senior counsel is not in station.
This is matter in the month of October. Yes, sir, 67.
My lords, in the meanwhile, my lords, since annexure D is in Kannada, my lords, if roster changes, then it's no problem. Or else, my lords, it has to be translated, please. Annexure D.
I said in the month of
Please,
October.
I won't come.
Yes.
Great.
67. S. Venkata.
This is the
Appear for the petitioner, my lords, and proxy counsel, the on-record counsel is held up to the DRT, my lords. My lords might
I
have
have
it on
one
any other
submission to
day.
make. This is the grossest abuse of process. Your lordship, my lord has held.
My lords may
specifically-
pass over, my lords.
Give me
He's
1 minute.
held up
I'm
in-
just pointing out something.
So
Please
that-
see 175, my lord. Page 175, the objection statement. And this is a, your lordship had imposed costs of 1 lakh on them for having abused the process of court on the 14th,
Page number?
page number 175. 14th of October 2025. This is, my lord, a case where the sales certificate was confirmed in the year 2015. Challenged before this honorable court, rejected, comes to an end. Thereafter, my lord, different forms of writ petitions were filed before your lordships. Your lordship, my lord, at page 175 considered this, and can I humbly request, my lord, to kindly come to page 182, my lord,
Yes.
para 8.
Hmm.
Litigation started in the year 2008. The proceeding by the court has discussed about several writ petitions filed from the DRT till Supreme Court. Sales certificate dated 23/1/2005, impugned before this court, which is not interfered or stayed either by this court or Honorable Apex Court or by DRT, DRAT, and DRT proceedings are pending. The petitioner never sought for interim order from DRT. In the earlier litigation, sales certificate was questioned. Division bench has clearly observed petitioner could not make any ground why the sales certificate has to be set aside. What are informatives in issuing sales certificate? Under which law? What is the violation? What are the provisions violated? Such an order had attained finality. SLP file is withdrawn. Review is dismissed. All these counts. Petitioner cannot come before this court questioning the sales certificate. Second round is when the matter is pending before DRT has not sought for any interim orders. In litigation of this nature, which is pending in the year 2009, sales certificate in the year 2015, there cannot be any order from this court. Bank was not made party. And then, Lord, your lordships imposed finally a cost of 1 lakh on them. This is also not paid. Then, Lord, I had moved a writ petition to direct the recovery office to hand over possession of the property. Your lordship disposed that of, my lord, at page 240 on 12th of March 2026, 240. Directing, my lord, that it should be done in 4 weeks' time. What he does is, there are at least 3 suits he has filed. He files 1 more suit. In that suit, he asks for an injunction. Trial court says it's a matter in Surface Act. And then he says, no, it's not Surface, it's the Recovery Debts Act. Does not grant injunction. Against which this writ petition is filed. And in this writ petition, my lord, an order of status quo is obtained against me. And most interestingly, I have filed a caveat as Union Bank of India. How the suit is filed is Corporation Bank, now known as Union Bank of India. And an interim order is granted by this court, my lord, and your lordship's order is not even brought to his notice. Both the orders are not brought to the notice of the court. And on that basis, my lord, an interim order is obtained. It's really a complete abuse of process. This can't be worse than this, my lord. File 3-4 suits. 2 suits are rejected.
I'll have this matter as a first case tomorrow.
Well,
Then counsel for the petitioner seeks time, as the counsel is before the DRT. Then the senior counsel, heard the learned senior counsel in part. This is matter as first on the top of the list tomorrow.
great.
Cell number 68.
Waiting for respondent number 3, my lords. My lords, a small submission, my lords. We'll file a statement of objection, my lords. Kindly grant us 2 weeks' time, my lords.
We do not have any objections. There's an interim order in force, your lord.
Post after 2 weeks at the request of learned counsel respondent, interim order earlier granted is extended. Yes.
Cell number 69. Preliminary hearing B group. Tom Shekara KH for petitioner.
It's appearing for the respondent number 1, my lords. My lords, we have to seek few instructions from the board, which is respondent number 1.
Yes, this matter in the month of September. Look at it. Interim order is there.
Interim order is there.
Interim order earlier granted.
Short
is
date may
extended.
give, my lords.
Huh?
Date may be fixed.
On 28th of September, interim order earlier granted is extended.
Cell number
Grateful,
70. 70, Nagaraj B.
Is appeal for the respondents, my lord. This is the matter wherein, my lord, the petitioner is seeking for a permanent connection. My lord, what has happened, my lord? There is this OS suit which has been pending between the parties.
Neo is not here.
Please,
List in the month of October.
Great.
Yes, 70, no representation.
Cell number
Yes, 71.
71,
Here for the petitioner's counsel.
Purushottam.
Respond.
Petitioner respondent.
Petitioner.
R. Chandrasekhar.
I mean, my lordship,
Now
senior
respond.
counsel
I'm
has
sorry.
been.
Sorry.
Yes.
You are saying you are petitioner. Sorry. I should have come here. My apologies. You should go there.
He's seeking time, I think.
Very well, Mulad. I don't want to say anything more. Youngster comes and says, Mulad, I have never opposed.
List is matter.
Senior.
Any date, Mulad, if you.
On
if-
23rd of, huh?
Tomorrow or Thursday, my lordship.
23rd of September. Look at, interim order is there.
Yes, sir.
Extended till then.
Cell number 72,
Before 17th, if is possible, Mulad, because he has some inconvenience thereafter, so for about a week.
17?
17th, Mulad.
Yes.
Grateful, Mulad. Great.
Yes.
Right. I'm seeking for adjournment for 2 weeks, my lord. My
cell number 72,
70.
Yes, after 2 weeks.
Interim order maybe.
Interim order earlier granted is extended. Yes, next 73.
73, Nischales.
The petitioner.
Yes. Serve the caveator.
I have served the copy. I served the copy. I have to put on acknowledgement also.
No representation for the respondent. List is matter in the first list tomorrow. Is 74?
Cell number 74,
For the respondent, my lord.
Yes.
Prabhakar Shetty, SK.
I filed an application for amendment of counterclaim. That has been amendment of prayer in the counterclaim. That application is rejected. I preferred this petition. The notice is served on the other side. They filed wakalat.
All of them are appearing. You appear for all the respondents?
Yes, my lord. There's only one respondent, my lord.
Yes.
My
3rd
lord,
of September.
My lord.
Interim order is there?
Interim order.
Interim order.
My lord, it's a suit for eviction. They're not even paying the rents, my lord.
We'll see, we'll see.
Cell
Third,
number 75,
Not date, my lord.
third.
3rd September, sir.
Much obliged, my lord.
75.
75, Prakash MH.
Yes, no representation.
For the petitioner. 75.
You have an interim order?
Yes, yes.
Yes, interim order earlier granted is extended. Listed on the month of October.
Cell number 76,
Corrected 74.
Yes. Same like the 76 and 70?
3rd of
74.
74 are connected. Yes, 77.
cell number 77,
Petitioner seeking adjournment.
Yes, 2 weeks.
Interim order.
Interim order earlier granted is extended. 78.
78, Subbareddy KN.
It's time to file objections.
Yes, at the request of learned AGA, 2 weeks. Yes, 79.
Cell number 79,
Look at it, interim order is there extended. 79.
My lord, I seek for a day's accommodation. Kindly have it tomorrow, my lords.
No copies have been served on me. I appear for first
My lord,
respondent.
I have served, my lord. There is acknowledgement also. Kindly have it tomorrow, my lords.
Yes,
The
this is
urgency
matter
this.
tomorrow.
On the top of the list, if your lordship.
Cell
So
number
I am
Why?
appear for
Because you're
first
seeking
respondent,
adjournment?
my lord. First respondent, my lord. First and respondent has not been served with any copies.
My lord, we have served with the copies. Their colleague has received. Anyway, I'll
Only
serve
the
it, my
second
lords.
respondent has been served.
If you want the matter to come tomorrow, do
I'll
it.
serve it,
Or
my
else I'll take it up in the month of September.
I'll serve it, my lords.
Yes.
Grateful.
Next.
final hearing, cell number 80, Chandrasekhar.
No, I'll not take a final hearing. List it in the month of October.
Yes, ma'am.
Yes.
Some urgency, my lord.
Huh?
There is some urgency, my lord. Request
What
for a pass.
urgency for a final hearing matter?
Seal number 80, my lord.
Huh?
Seal number 80.
That's what I'm saying. Final hearing matter, what urgency? Yes.
Serial number 82 is a review petition, my lord. Final hearing matter, 2004 suit, my lords.
Huh?
It's a 2004 suit, my lords. Petitioner is a senior citizen. So the
which one?
Serial number 82, my lords.
He's at 80. Yes, 80, 81. Give dates in the month of September. Yes, yes, 82. What is this review?
Lords.
My lord, there is an interim order in seal number 80.
Interim order will be extended. Yes.
My lord, the petitioner, the review petitioner is the plaintiff before the trial court. It was a suit for specific performance filed in.
Where is the order of the court first? What is the
Lord,
review?
page number 19, my lords.
Give that.
Yes.
The 230 matters have not come. Let,
But the order starts at page 19. The relevant part is at page 21, my lords.
yes, where is this order?
Page 19, my lords, of the review petition. At page 21 is the relevant part. The trial court had allowed the amendment application filed by the petitioner seeking the relief of refund of earnest money, which is an admitted amount, my lords. By the impugned order, this court has set aside the trial court order on the basis that there is already a WP 56505 of 2017, which was withdrawn by the petitioner. My lords, there are only 4 dates which are relevant. 30/8/2017, they were.
This matter also tomorrow. Yes.
Till number 83.
Appearing for respondent, my lords.
Petitioner in this case. My lord,
We have already filed the death certificate, my lords.
that is under surprise, my lord. I have challenged the order passed by the magistrate, my lord. Under section 14, what has happened is we have filed an application for memo for appointment of commissioner. The trial court has rejected my memo.
Which one? Parted, it's a DRT matter.
DRT matter. 2006, the sale has taken place. We issued sale certificate in the year 2006. What happened? The auction, the borrower challenged the proceedings before the DRT. So it went on for years together. In 2011, that appeal was dismissed. In between, what happened? The bank has filed a OA. In the OA, the guarantor who has mortgaged the property, he has been discharged. Partially, the OA was allowed.
Where is the impugned order? Please come to the order. Yes.
Annexure A, my lord. Page number 24, my lord.
Page number?
24. I think one page is missing, my lord. Just
Oh, the case is posted for hearing on the said memo.
no, my lord. Subsequently, one more. That page is missing, my lord.
Take that. Is not entertained at present is the order.
Yes, my lord. The thing is, there was no delay from the bank, my lord. What has happened is, in OA, the property which has
This
been sold.
petition is of the year 2024.
Yes, my lord.
And on that order, it is pending on this file of this court.
No, no, not my lord. The thing is, we have issued sales certificate in the year 2006.
So whatever it is, what kind of an order is this that I am not able to understand that it should be pending before this court from the last 2 years? Hence, the memo and affidavit filed by the council is not entertained at present.
What happened? We filed one memo. Earlier to that, one more order is there, my lord. That was dismissed.
Where is the rejection here? What is the, why did you question this order?
My
And
lord,
why the writ petition is pending from 2022, 24?
no writ petition is pending, my lord.
Oh, this is
No writ petition is pending.
part third matter, 2024 writ petition, which is the impugned order. According to you, this is the impugned order. And what is, according to you, what is the order? What is the nature of this order? How it is causing prejudice to you?
My lord, kindly take the order dated 18/1/1924, what I have produced now.
That's what I'm looking at.
The counsel for the
Is it the
petitioner has
impugned
filed
order
a
I'm
memo.
asking? Is it
That
the
is what,
impugned order?
in that only matter. That's what we have changed. We have filed a detailed affidavit along with the memo. Earlier, the trial court has dismissed my memo on 20/12/2023. Subsequently, we filed a detailed.
It said it didn't reject your application. It said for the time being, I'm not taking it into consideration. For that purpose, you come to this court.
So much prior to that, one more memo he has dismissed, my lord. That also I have changed it.
Where is that dismissal memo? Where is that order?
It is there, my lord. Page number 24, my lord.
Page number 24.
24
The
of
counsel
my-
for the petition has filed memo with a copy of the order passed by the DRT
Yes,
for
my lord.
appointment of a court commission to take possession of the secured property. As such, the case is posted for hearing on the said memo.
On
But what
20
is there to question on this?
2/12/2023, I am challenging the memo filed with the counsel for the petitioner for appointment of a court commissioner is rejected. That I have challenged. Subsequently, we filed a memo and again we moved a memo requesting the court to consider our application because earlier memo, the explanation was not given by the counsel appearing in the petition, my lord. Subsequently, along with the memo and affidavit, we have filed.
And
That
there is no interim order in this.
there is no interim order.
What
Final
happened?
order. Final order.
What happened to the proceedings, pending proceedings?
Which pending proceeding, my lord? It was disposed of in 2011. CMIS was allowed. The section 14 application filed by the bank was allowed in 2011. In between, what happened? OA was filed by the bank in 2009. In the OA, what happened? The guarantors, this thing was discharged. So bank could not able to proceed with taking possession of the property. So bank challenged the OA partial allowance of the OA in DRT Chennai. That came to be allowed in the year 2023. Immediately after allowing our appeal, in 2023, we moved this memo before the magistrate, narrating all those things, why there was a delay from the bank. The memo, earlier memo, the bank has not mentioned all these things, my lord.
Who appears for the respondent?
Respondent. Parashuram KR.
No, I appear for petitioner.
Connected.
The auction purchaser has filed one more writ petition, that is 15.
PB Ravi
What is
Shankar.
this?
I have purchased the property way long back in days.
Hmm?
Possession is not delivered. Possession is not delivered. Now the bank is pursuing the petition at serial number 83.
That's what I'm asking. Who appears for the respondents?
Respondent PB Ravi Shankar and MA Rajendra.
Somebody was appearing online now.
And Mr. Ravi Shankar represents the auction buyers in 83.1. Is the petitioner. I am representing Mr. Ravi Shankar.
Some advocate had represented now.
No, no.
No, somebody
Only
represented.
only one.
My lord, under section 14, there is no necessity of hearing the other side, my lord.
This matter on the top of the list tomorrow, along with that other matter. No representation on behalf of the respondents, counsel for the petitions are before this court. $230 matters have not come. Tomorrow. Matters have not come.
Since he was, matter which you mentioned, the Honorable Supreme Court said.
No, but the file is not here. We'll list it on the top of the list tomorrow.
Now they are already, my lord, doing this. They have ripped off, my lord,
Almost
the
it might
entire
have-
theatre, which was one. They have ripped off, my lord, the entire theatre in no time with, my lord, a reserve police van. And your lordships may kindly, my lord, see the atrocity, my lord. In no time. My lord, morning 5 o'clock they go there. My lord, I don't understand executing the orders. Somebody who has to go there at 5 o'clock. The Honorable Supreme Court said that till September 30th, you will have to, before September 30th, on or before September 30th, you will have to vacate.
There
the
is a
premises.
Supreme Court's
Your
order.
lordships may kindly have this. Your lordships may kindly have this. I'll assist the Honorable Court. Kindly, my lord, see the Honorable Supreme Court's order. Sir, the Honorable, I'm sorry, my lord, I have just underlined it. Your lordships may kindly accept my apologies for that. This is what, my lord, is the Honorable Supreme Court's order. And your lordships may kindly go to the previous order, my lord, the executing court, my lord, would go ahead and, my lord, this order was passed in their presence. The Honorable Supreme Court passes this order.
It says 30th September.
Kindly permit me to read the order, please, my lords. Complete order.
Yes.
It's complete order. First portion is, my lords. This order is kindly the date also, my lord. Previous page, 20th May 2026. We are not inclined to entertain these writ petitions, special leave petitions, and the same are accordingly dismissed. However, petitioners are allowed 3 months time 3 months time to vacate and hand over peaceful posture of the premises in question. And next, and shall pay entire mean profit, it amounts to 20 crores now. Subject the petitioners furnishing undertaking in the registry of this court that they will vacate and hand over the vacant portion of the premises and pay the mean profits on or before 30th. Mean profits you have to pay on or before 30th. No undertaking is.
Fortunately, there is a confusion in the order.
Undertaking they have not filed. Anyhow, no undertaking was filed. I was there.
Not undertaking.
Please.
That the court is referring to the mean profits or
Uh,
for the possession also.
Your Lordship may kindly
There is
note
a,
this.
there is a confusion.
Initially, since I can.
Having said so.
I can assist
again-
the Honorable Court on this point, my lords. The matter came up since I had appeared before the Honorable Supreme Court, previous page, your Lordship may kindly see. What happened was, the SLP was dismissed. The Honorable Supreme Court said, we'll get 3 months time. Then we said, my lord, mean profits also they have to pay. Then, my lord, the time was not granted initially. Then, subject the undertaking of filing and undertaking. Filing and undertaking word is there, my lords. Undertaking, they are not never filed in undertaking. Before that, even now they
To
don't
do that,
say.
my lord, I have time till September 30th.
Then where is the
Lord,
question
it's a
of filing
composite
undertaking
order.
September 30th?
It's a composite order. It's a composite order, my lord. Your lordship sees, my lord, what the trial court does. My lord, the trial judge notices, my lord, the Supreme Court, the Honorable Supreme Court matter is there. This order is there of the Honorable Supreme Court. The trial court would, my lord, say what exactly is my learned friend saying.
Have they filed
Trial court would
undertaking?
say, 1 second, sir, it's my petition. Kindly bear with me. Kindly, I will not disturb you. The Honorable Trial Court would say that you have not produced any proof of having complied the Honorable Supreme Court's order. Therefore, I am ordering execution. Now, my lord, to do that, I have, my lord, with no unambiguous, my lord, there is no ambiguity at all. In unambiguous words, my lord, till September 30th, my lord, kindly see, my lord, the atrocity, what they, my lord, they have shambled down, my lord, the projector which is costing more than 10 to 15 crore rupees. Kindly see this, my lord, I am not
Let them say
Please
about
see
the Honorable
this,
Supreme Court's
kindly
order
see
that the
this.
execution
They
is
have, my
going.
lord, ripped off all the seats. They have, my lord, shambled all the projectors. The first thing, what,
August,
one nimsha, Hegde,
one
please,
nimsha,
kindly
20th.
bear with
No,
me.
you
It's my
please
request
say
to you,
about the
please.
order.
Now, my lord, in 1 minute, they went and tore off the entire screen. My lord, this is one of the most celebrated theatres, one of the theatres which has the best of the facilities. My lord, if they were doing it, if they had done it, my lord, after 15th, I don't have a voice to say if I had not complied. Then, my lord, I would have at least dismantled my possessions.
Yes,
Kindly
yes.
see, my
Yes,
lord, a screen which costs, my lord, more than 18 crore rupees, they have torn off with a blade. Your lordship, kindly see these pictures, my lord. In no time, and my lord, a reserve police van comes, armed with, my lord, more than 20 to 30 of them to take over, my lord, in the early hours of the day. And we move the execution court at least to clarify. Kindly see, this is not the way this court should have understood the order. The advancement application is also not taken.
August 20th is the, May 20th is the order. Honorable Division Bench dismisses their appeal. And my lord, then the matter goes up to the Supreme Court. From May 20th till now.
You could have waited till September.
Yes.
Your Lordship may kindly, the time is 3 months. They don't give an undertaking. They, without giving an undertaking,
There is a
the two
confusion.
aspects, may I humbly submit, the two aspects. If they give undertaking, there is a time granted. If they don't give an undertaking, and now
not
they
like
say
that.
undertaking will be.
It only says if they don't do it, these are the consequences, is not the order of the Supreme Court.
SLP, your Lordship may kindly see, they have
And
not.
the execution petition, my
This
lord, is
aspect we
filed
have
in
to-
January.
No.
My lord,
Only the
execution
judgment order.
petition is pending from
my lord,
January.
your Lordship may
My
kindly
lord,
see.
suddenly,
They
the
don't-
moment, my lord, an interpleader suit is filed. My lord, what happened?
They have not brought the entire facts to Honorable Court. My lord, is like this. Eviction was ordered by the trial court. That was taken before the Honorable Division Bench of this Honorable Court. The Division Bench confirms the eviction, my lords, granted some time, which was long back over. 4 months. That was long back over last year. And then the mean profits now comes to 20 crores. Then they approach the Supreme Court against the Division Bench order. Kindly see the Supreme Court order, my lords, in the first page itself. Against the final, why they have approached the Honorable Supreme Court, my lords, judgment, challenging the judgment of the Honorable High Court in the RFA number. First page, your lords may kindly see. That judgment is to produce it. The judgment says that the tenants, they should vacate and hand over the possession. Kindly see that the top, my lords, page 35, since they have not come out with all the facts. Page 35, my lords. Arising out of the impugned final judgment and order dated 13/10/2025 in RFA number 816 of 2024. That's
I understand.
judgment is to hand over the possession.
I understand that
Please.
the order of this court, I mean, the Honorable Apex Court has affirmed the order.
Affirm the order.
However,
Granted 3 months time.
3 months time for what?
Your last vacate to vacate. Line number 3 dismissed. Petitioners allowed 3 months time to vacate.
For the next line.
Now, my lord, the payment of the arrears of maintenance, arrears of the mean profits, which amounts to 20 crores.
When-
They paid only 1 crore.
No, when that comes, the court says mean profits and with regard to possession also.
And undertaking they have to file. Your lordship, kindly see, the two very clear, order is very clear.
If they don't file the undertaking, how can the
Subject,
trial court?
3 months is granted.
Court
May I read
consider
it
this
with
order
kind
is-
permission, my lords? May I read it once again for my benefit, please, my lord. Kindly permit me to read it once again, my lords.
I see
SLP
that.
dismissed, however, petitioners allowed 3 months time to vacate and hand over the possession premise in question shall pay the entire mean profits. Then condition, subject to
No.
3 months time to vacate.
First line speaks about 3 months and then mean profits. Then when it comes to the next line,
Please.
again speaks about for the delivery and mean profits and
My-
grants
my lords, if you-
and grants time, specific time till September or.
No, my lords,
whatever.
subject to furnishing undertaking. Let them say, have they furnished an undertaking? At least let them say
If
before
they
this
don't
all.
furnish the undertaking, if they
Order
have
will not, the 3 times months.
not furnish the undertaking by the date, you can do anything.
No, my
you
lord,
want.
no, for giving the undertaking.
For furnishing the undertaking, court has not given any time.
No, my lord, which means, my lord, that aspect, now they can't say that we will furnish the undertaking at any point of time. They want to enjoy the benefit of the Honorable Supreme Court subject to undertaking. Otherwise, the time is over. Even if lordship consumes this matter, your lordship may kindly, 3 months would lapse. 3 months would lapse, my lords, on August 20th from May.
What is the date? What is this 30th of?
30th of September
So, my
2026.
lords, 20th May, 2026, 3 months will lapse on August 20th. Have they given an undertaking? No. If they give undertaking, my lord, it would be extended till September.
That is the order of the trial court.
The
Order
trial
the
court's
trial
order, my lord, is the previous one. Your lordship sees, my lord, the trial
Trial
court
court
would
has considered
simply
this.
say, takes note of the Honorable Supreme Court's order.
Yes.
And
Page
my
number?
lord, but the trial court would opt to interpret it, my lord, in its own fashion, saying that since there is no proof placed by me,
Yes.
my lord, I'm not even notified in this case. I'm
Even
not
now,
even notified in this
even
case.
before this on the court, do they say that they give an undertaking? Even now they don't. They are not given undertaking. I spoke to the instructor counsel in Supreme Court.
Not, why you are not file the undertaking?
No, my lord, in fact, my
Want
lord, we,
no,
we
no.
are contemplating, my lord.
Want-
My lord, I am ready to give that
You
undertaking.
want to have when you want to have the benefit of the order, you should also comply with what has been
In fact, my
ordered.
lord, in fact, your lordships may kindly see, there are 2 intervening facts, my lord. There are 2 intervening facts. My lord, this is, I'll only take 2 minutes. Now, my lord, I was ready to give undertaking, but my lord, them and their, my lord, another adversary party, both of them sent legal notices to me saying that hand over the possession to me, hand over the possession to me. Then, my lord, I ended up filing an interpleader suit before, my lord, the City Civil Court, which is reserved for orders. Please tell me whom I have to hand over. My lord, this is the interpleader suit which I filed.
You file the undertaking by tomorrow.
Yes, my lord, I'll file that. My lord, in the meanwhile,
Let them stop all that.
yes, my lord, they should stop, my lord. Your lordship sees, my lord, they have already caused total damage. My lord, they have pulled out the projectors. My lord, at least they have caused in a blink of eye, my lord, they have caused a loss of not more than, my lord, 20
Wants
crores.
to avoid the execution. He has done it. It's 20 years position is with him. Now,
From
20
January,
crores.
there is
Your lordship,
execution
kindly,
petition
20
pending.
crores is the
Nothing
mean
happens.
profits. 20 crores is the mean profits.
Let them
Without
file
paying, your lords may kindly see,
file
if he
an
files an
undertaking,
undertaking before the Honorable Supreme Court, my lords, we will report this Honorable Court. 20 crores the mean profits. He doesn't want to pay the 20 crores
Meanwhile, my
because
lord,
his game is
everything
this.
should stop.
Your lords may kindly, his game, your lords may kindly understand the design. He doesn't want to file by undertaking because the moment
What
he
I'm
files
saying
undertaking,
is- what I'm
he has to
saying
pay
is,
20 crores.
By tomorrow morning, he has to file an undertaking before the.
That
Honorable
undertaking he has to give before this Honorable Court, that he is filing an undertaking before the Honorable Supreme Court.
Do anything till tomorrow. I'll list this matter tomorrow again.
Now, my lord, your lords may kindly see. Now, kindly appreciate this.
We can't, the trial court had committed a grave mistake.
May
in
submit like this.
understanding the order of the
May submit only this factual aspect, my lords. Now, my lord, what they said is the memo court amendment. They said we want to remove all our apparatus. They started removing. They are in the process of removing their apparatus. We
I am
want to remove
sorry.
their seats.
My lord,
If
not
they
even
are not
one of
removing
a
the
person
seats,
is entered.
your lords may kindly note that they don't want to remove and take away.
On-
Let them say, they say this cinema theater, they built in our property. Now they want to say there cannot be an exit before the court. I mean, they stated, my lords, process server or executing court's executing office, process officer. They said we want to remove the chairs and all the projectors. They are removing it.
No, my lord,
Let them
no.
tell before
I
they
wouldn't,
don't want
I
to remove
wouldn't,
it.
my lord,
We will
remove
keep
and
it
throw
there
my
only.
projectors.
They
which
removed
cost me
it already. About
crores of
400
rupees like
chairs.
that.
After 1,000 chairs, they removed about 400 chairs.
Both
Let
of
them
them.
keep.
No.
Let them keep the chairs there only.
Do anything. don't, neither you nor. they
Everything
don't-
should be halted, my lord.
don't-
Everything let everything
kindly
be
see, as far as the
halted.
execution is concerned, your last may kindly postpone it to tomorrow. Tomorrow, let them say, my lords, what they want to say. Because now what they're doing is, your last may kindly see, the game is this. Today morning, they said before the officer, we want to remove the chairs, you can't hand over the position. We said simply lock over and hand over the building. It's our building.
That's what I'm
Now
saying.
they want to remove it. They are removing it, my lords.
I said they will also not do, nobody should do anything.
Yes, they should not remove anything.
Yes.
And they should not also enter.
Yes,
Your lords may
now,
kindly
my
say,
lord, I can't
my lord-
even do anything.
my lord,
Everything
may I
is
pray
removed
this, my
from
lords?
there.
Let the
Lord, I
court
can't
come in.
even do
Let the
anything
court
there.
come in, lock and keep it in his position, my lords.
Honorable Apex Court.
Now, one sentence, my lords. Now the court, the process server is, let him, the
No, my
position
lord,
will
it's as
continue with
good as
him.
executing
Let
the
the-
order. No, my lord,
He
that
is in
can't
the-
be done. It's as good as, my lord, let it,
No.
my lord, we will also not do
The
anything.
police force has come today morning, my lord. The police force, they resisted it.
In, what is this number and all?
My lord, execution, my lord.
The Honorable Apex Court is in SLP civil number 8311-8313-28313 of 2026, dated
My lord, dated 20th/5/2026.
20th/5/2026, has passed an order. This first para extracted. Passed an order. Thereafter, the respondents herein filed execution. The executing court has allowed the application. It is a contention of the learned senior counsel appearing for the, representing the learned counsel of the petitioner, that when he had time till September 30th, a question of executing the order does not arise. Learned senior counsel representing the decree holder, the respondent submits that in the said order, the court speaks about 3 months, and that 3 months' time has already elapsed. Further, even till now, they have not filed any undertaking affidavit as observed with the Honorable Apex Court in the order. Learned counsel appearing, learned senior counsel submits that by tomorrow, they'll file an undertaking before the Honorable Apex Court, and a copy of it will be placed before this court. According to the petitioner, the respondents have damaged the property.
It's the court, court process server, please.
The respondents have damaged the screen and other furniture. According to the respondents, the petitioners themselves are removing the furniture and other material from the premises. Considering the gravity of the situation, and also considering the order that is passed by the Honorable Apex Court, on the face of it, it appears that the time is granted till 30th of September. In those circumstances, this court is passing the following order. The execution, the order that is passed by the trial court, the operation of the order of the trial court dated
20th August 2026, my lord.
20th August 2026 is stayed till
It's actually 22, or this 22.
August 2026.
No, my lord, your last may kindly take one aspect.
Till tomorrow.
In the meanwhile, my lord, the court, my lord, let the premises be in his position. Now they will remove it again. There's whatever test
It is as
dismantles.
good as then, my lord.
No,
giving,
it's
my lord,
already,
Lord, it's as good
already
as,
everything,
as good as, my lord,
something have been
allowing the
removed from
order
there.
to continue.
Since morning, there are about lot of policemen are there.
No, the petitioner, neither the petitioner nor the respondents shall not remove any articles, any material from the premises. Number 2.
Status quo we maintained as on today by the court process server, my lord.
Number 3, undertaking affidavit before the Honorable Apex Court, and as well also a copy of it shall be placed before this court. Let's call this matter tomorrow at 2:30.
2:30, I'm so. My lord, the registry may kindly be directed to communicate, my lord, this to the court, Amina.
See, it's directed to communicate this order.
Greatly obliged.
But by tomorrow, if the affidavit is not
We
filed,
will file it, my lord. We will comply.
I
We will
will
comply.
dismiss
We
this
will.
with
With the, your last may kindly see, Mean profit is
Exemplary
20,
cost.
20 crores is there.
Whatever
Honorable
it
Supreme
is.
specifically said he has to give an undertaking
The
and deposit.
undertaking affidavit as per the order of the Supreme Court shall be filed, or else the writ petition shall be dismissed with exemplary costs.
My lord, one submission.
ರಿಜಿಸ್ಟರ್ ಫೋನ್ ಮಾಡಿ ಅವ್ರ ಅರುಣ್ ಕುಮಾರ್ ನಂಬರ್ ಇದೆ ಅವ್ರಿಗೆ ರಿಜಿಸ್ಟರ್ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿಸಿ ಈಗಲೇ ಇಲ್ಲ ನಿಲ್ಸಲ್ಲ ಅವ್ರು.
ಮೆಮೊ ಸರ್, ಮೆಮೊ ಬಂತ?
ಏನ್ ಸರ್ ಫೈಲ್ ಬಂದು ಯಾವ್ದು ಏನ್ ಫೈಲ್
ಇದು ನಮ್ದು ಆಫೀಸ್ ಕಾಪಿ ಮೇಡಮ್.
ಬೇಕು ಇವ್ರೆ ನಿಮ್ ಫೈಲ್
Photo
ಬಂದಿಲ್ಲ
sir.
ಇನ್ನು ಅವ್ರ ಆರ್ಡರ್ ಡಿಕ್ಟೇಟ್ ಬರೆಯೋದ್ ಬೇಡ್ವಾ? ಇದನ್ನ ನೋಡ್ಕೊಂಡೆ ಮಾಡ್ತಾರ ಅವ್ರು. ಫೈಲ್ ಬಂದಾದ್ಮೇಲೆ ವಾಪಸ್ ಫೈಲ್ ಲಿಸ್ಟ್ ಆಗಿ ಬಂದಿಲ್ಲ ಡಿಕ್ಟೇಷನ್ ಅವ್ರು
ಅಲ್ಲ, ಲೀಸ್ಟ್ ಇಲ್ಲ, ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ವಿ ಬೆಳಗ್ಗೆ ಮಧ್ಯಾಹ್ನ. ಹೌದು ಸರ್, ಮೆಮೊ. ಹೌದಾ ಸರ್?
ಅಲ್ಲ
Petition 6519. ಹೌದು.
ಜಸ್ಟ್ ಬಿಫೋರ್
ಈಗ ಬರುತ್ತಲ್ಲ?
ಅದೇ ಇವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಲೇಟ್ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು.
in the presence of learned counsel
ಇಲ್ಲ
and
madam
senior
ಇದು
counsel
ಆ
of
ಫೈಲ್ ಬೇಕು ನಮ್ಗೆ ಅದ್ರಲ್ಲಿ ಅಂತಾರೆ ಆ ಫೈಲ್ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ ಹೇಳಿ.
DHR and taking note of the seriousness of the matter, and the serious damage already done to the property,
ಈ ಆರ್ಡರ್ ಶೀಟ್ ಸೈನ್ ಆಗಿದ್ರಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಇಟ್ಕೊಂಡು ರವಿ
petition number is ಅಲ್ಲ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ನೋಡಿ.
ಇನ್ನು ಕಾಸ್ ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ.
ಹೌದಾ? The Honorable High Court in writ petition
ಒಂದು ನಿಮಿಷ ರಿಪಿಟೇಷನ್ ನೋ ಬಂದಿಲ್ಲ ಕಾಪಿ
FR number
20
FR number
ಆ 230 ಮ್ಯಾಟರ್ ಕಳಿಸಿದ್ರಾ
27014.
ಯಾವಾಗ?
First please direct immediate
ಅದಾ
all the process
ಫೈ ಬೇಗ ತಗೊಂಡು ಅದು
directed the parties
ಏನೇನೋ ಅಲ್ಲಿ ಇದೆಲ್ಲ ಪ್ಯಾರಾಗ್ರಾಫ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ
not to proceed. All the process and direct
ಫೈಲು
parties.
ಬೋರ್ಡ್ ಅಂತ ಹೇಳೋ ಇವ್ರು ಹೇಳಿದ್ರು ಹೋಗಿದೆ ಅಂತಾರೆ.
ಈಗ ಮೇಡಮ್ advised to stop immediately. All
ಅದೇ ಇವ್ರ ಫೈಲ್ ಹೋಗಿದೆ 3 ಗಂಟೆಗೆ ಅಂತ ಫೈಲ್ ಹೋಗಿರೋದೇ 3 ಗಂಟೆ.
ಮೇಡಮ್ ಹತ್ರ ಹೋಗಿದ್ಯಾ ಸರ್? ನಾವು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದು. ಹೌದಾ? ಹೌದಾ?
It will be a disobedience.
6519
3 ಗಂಟೆಗೆ ಹೋಗಿದೆ ಅಂತ
Disobedience. It will be considered as disobedience.
ಹಲೋ ಅದೇ ಕಳ್ಸಿದ್ದಾರೆ ಅಂತಾರೆ ನೋಡಪ್ಪ ಫೈಲು.
Disobedience.
ಅದೇ ಇವ್ರ ಫೈಲ್ 1 ನಿಮಿಷ 3 ಗಂಟೆಗೆ ಹೋಯ್ತಂತೆ ಸ್ಕ್ರೂಟ್ನಿಗೆ ಫೈಲು. ಆಯ್ತು ಇವಾಗ ಹಾ
ರೆಗ್ಯುಲರ್ ಮೆಸೇಜ್ ಕಳಿಸು. ರೆಗ್ಯುಲರ್ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲ ಅದನ್ನೇ ಕಾಪಿ ಮಾಡಿ ರೆಗ್ಯುಲರ್ ಮೆಸೇಜ್ ಕಳಿಸಿ ಮಾಡಿ.
ಆಯ್ತು ಲಿಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಹಾ 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 ಆಯ್ತಾಯ್ತು
ನಿಲ್ಲಿಸ್ಬಿಡಿ ಅಂತ ಹೇಳಿ ಇನ್ನೊಂದ್ಸಲ ಫೋನ್ ಮಾಡಿ. ಅರುಣ್ ಸರ್ ನಿಲ್ಲಿಸ್ಬಿಡಿ ರಿಜಿಸ್ಟ್ರಿ.
ಆಯ್ತಮ್ಮ ತಗೊಂಡ್ ಬಾ. ಓಕೆ ಓಕೆ
ಆಯ್ತು ಬರ್ಲಿ ಬಿಡಿ.
ತಗೊಳಪ್ಪ ರವಿ 1 ನಿಮಿಷ ನಿಮ್ ಫೈಲು ಇನ್ನು ಬೋರ್ಡ್ಗೆ ಹೋಗಿಲ್ಲ, ಈಗ ಜಸ್ಟ್ ಹೋಗಿದೆ. ಕುತ್ಕೊಳ್ಳಿ ಕೊಡ್ತೀನಿ ಒಂದ್ 2 ನಿಮಿಷ ಅದು ಫೈಲ್ ಬಂದ್ಬಿಟ್ರೆ. ಯಾಕಮ್ಮ
ಏನೊಂದು ಮಾಡಿದ್ದಾರೆ
ಏನು ನಮ್ಮ
ಅದು ಆ ಕಡೆ ಪ್ರಿಂಟ್ ಆ ಕಡೆ ಜರ್ಬಿಟ್ಟಿತ್ತು. ಬಂದಿಲ್ಲ ಅನ್ಕೊಂಡು ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದೆ ನಾನೇ ಸ್ಕೂಟರ್ ಲಾಸ್ಟ್
ಇನ್ನೊಂದು ಎರಡು ಸೇಮ್ ಇದೆಯಾ ನೋಡು.
ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಲ್ಲ ಆ ಕಡೆ ಇತ್ತು.
ನಾಳೆ ಫೈಲ್ಸ್ ಎಲ್ಲ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ, ಕೊಟ್ಬಿಡಿ ಅದನ್ನೆಲ್ಲ. ಅದು ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ ಚೆಕ್ ಏನೋ ಏನ್ ಈ ಬ್ರಾಂಚ್ ಅವ್ರಿಗೆ ಏನಾಗಿದೆ ಅಂತ ನನ್ಗೆ ಅರ್ಥ ಆಗೋದಿಲ್ಲಪ್ಪ ಈ DMC ಅದು ಅದು ಮಂಜುಳಾ ತೇಜಸ್ ಅಲ್ಲ ಅದು